Please, Your Lordships, I appear with Dr. David Dorset on behalf of the appellants. My learned friend, Mr. Peter Knox, Queen's Counsel, appears for the respondent. My Lord, as Your Lordships will have seen, this is our appeal from the dismissal by the Court of Appeal of the Eastern Caribbean.
Well, in a sense, not really, since none of the points were raised before the Court of Appeal. No doubt due to your diligence that they are in the notice of appeal.
Yes, well.
Obviously, we've been greatly helped in preparation by both sides, very clear cases and references. And it seemed to us, perhaps even slightly surprising, that you asked for the extra half hour in this sense, that the issues are relatively confined. Now, you've got to deal with, I think, one special issue, admissibility. But subject to that, defects in the summing up appear to be common ground. The extent to which they're common ground, you'll be able to assess for yourself. But if there are respects in which you feel that they are not common ground, in other words, they haven't been sufficiently accepted, of course you must develop them.
Yes.
But subject to that, it all turns on the proviso, doesn't it? And it may be that there'll be some advantage in hearing you on the points on which the onus is on you, but then hearing Mr. Knox explain, put his case as to why this is so clear that despite any apparent disturbance to the course of justice by the way in which the summing up was put, we should uphold the result.
Yes.
I mean, looking at the summing up, I think we can say, for our part, that we fully understand why it's common ground that there are defects in it, not just in individual statements, but also in its overall form, and including the repetitious nature of the first part and the almost endless recitation of evidence in the second part. One can't help feeling that the transcript cannot be perfect because it's in many points, barely grammatical. But that I don't know whether neither of you can help us on that. But yeah. Whatever the position, there it is, and yes. You've had our initial reaction.
Well, I'm grateful for that indication. I would seek, without seeking to tax Your Lordship's patience too much, to develop a little my points about the summing up, because before one gets on to the proviso, there is perhaps an important question of degree which arises. My learned friend says in his printed case that he accepts that the judge went too far.
Well, that's really why we asked you.
And to that extent, we're grateful for that realistic and fair concession. But, of course, before one gets on to questions of the proviso, it's important to have in mind just how far the judge went too far in our submission, because our contention will be that there are cases, and we say this is one of them, where one simply doesn't really get into the proviso territory because the summing up is so defective, so one-sided, that really the substance of a fair trial has not been afforded to the defendant at all. And it's not, therefore, really necessary to get very far into the question of whether the proviso should apply, which is not to say that I'm conceding at all on the proviso question, that if it is potentially an issue, it's an issue which favours the respondent. My Lord, what I was proposing to do, subject to Your Lordship's observations, and of course you'll stop me, I'm sure, if I'm going over matters that you don't need assistance with, is simply to take Your Lordship's relatively quickly through what we say are the highlights on the facts, and to look then at what some of the issues might have been in the light of that, and then to look at those parts of the summing up in particular to which we object. But I do that bearing in mind what Your Lordship has said about the familiarity that the Court already has with that summing up. And as Your Lordship will have seen, we, broadly speaking, take 4 points. I should have said, by the way, I think perhaps this is obvious and doesn't require saying, that Your Lordships will have picked up that there were certain other discrete points that we took in the original application for permission. Some of those points we got knocked back on the grounds that they were unarguable, so they're not an issue. And a couple of the points my learned friend concedes are unanswerable, so they're not an issue, unless Your Lordships are disposed to argue with that concession, which I don't suppose you are. So we are simply concerned with the question of whether the defendant received a fair trial and if not, with what consequence. My Lord, can I then just go straight into my, I hope, fairly brief look at some of the facts? And as Your Lordship has observed, we've been assisted by, and I'm grateful to my own friend for, a pretty consensual approach to the statement of facts and issues. So there's quite a lot of detail which is already in there. But, my Lord, there are a couple of things where it's important perhaps to look at the documents as opposed to just reading the statement of facts and issues in order to get a flavour of it. The company Providence Estate Limited, I think it's accepted, its common ground was incorporated in 1989. And, my Lord, if we go to the core bundle for those who are looking at the paper version, page 127, if one is using the computerized version, we can see the Memorandum and Articles of Association of Providence Estates Limited. I can skip over, I think, the memorandum, which occupies the first few pages. We see at 136 the initial subscribers, who were the two company incorporation agents, each taking one of the, in fact, 10,000 shares that there were in the company. And then over the page we get the Articles of Association. And I go to this because it formed quite an important part of the prosecution's case at the trial, that there were matters in here which were blindingly obvious, or should have been, or are somehow deemed to have been blindingly obvious to the defendant, to the defendants, and that from that we can, so the judge, as I shall seek to show, said one can infer almost immediately dishonesty on the part of the defendants. My Lord, the articles start with some typed provisions at 137 and 138, and then go over at 139 and following to what are obviously standard form provisions. And it's all fairly closely typed, as your lordships can see. But the point which was important from the prosecution's point of view was what we see at 139, at the bottom of that page on the left, transfer and transmission of shares, because you'll recall, of course, that although the original subscribers were subscription agents, it was common ground that in substance, at any rate, quite how the legal formalities of this were done doesn't seem to have been very clear, but in substance it seems to have been accepted that it was Rooney and Wood who were the owners of the company. And you'll see there that under 14A, there is provision in the standard way about directors declining to register a proposed transfer of shares. And then 14B, which is at page 140 at the top, is the passage upon which the prosecution placed a great deal of weight. No person shall be registered as a shareholder who is engaged in a business in competition with that of the company. We'll come back to that because the judge thought that was an important point against the defendant because of something that was said in the memorandum of association of the second appellant. And any shareholder who desires to engage in such a business or wishes to dispose of his shares must offer his shares for sale first to existing shareholders or to such personal persons as may be approved by the directors. And then the articles go on with extensive, I don't say it's particularly unusual or onerous. This is a 113 article, set of articles of association. I think Table A had 118, so it's not that unusual, but it's fairly closely typed and there's quite a lot of it, which is an important point in the context of what the judge later said about how obvious it must have been to our clients what the articles said. We then know that there was a first and last meeting of the subscribers of the company, which is at page 150. That took place in 1989 again, the 8th of September 1989, and your lordships will see that there it was recited that the substantive owners, essentially, of the company, using a rather non-legal way of putting it, were Mr. Wood and Mr. Rooney. Bottom page 150, agreed that Walter Alexander Wood III holds 60% of the stock, land and other interests owned by Providence Estate Limited, and agreed further that Owen Martin Rooney hold 40%. And it goes on to repeat that provision as a sort of declaration. Mm-hmm. And it doesn't appear that there was ever any greater formality to it than that. There doesn't appear to have been in evidence a register of members of the company, or indeed any evidence that any shares were actually issued other than the initial two. But it seems to have been accepted by both of those gentlemen that was the way in which they held the company. Of course, it was called Providence Estate Limited because its business was to own Providence Estate, which was a large tract of, at that stage, undeveloped land. And we know, and this is an agreed fact as well, that by 1990, the company owned that land. My Lord, we then go on to another meeting, which took place also in 1990. Well, I can take this largely, I think, from the Statement of Facts and Issues, which deal with it at paragraph 14. And this, if you want the reference, it's 2388 is the Statement of Facts and Issues. The document itself is at 156. In the core bundle. I don't think I need to go in great detail through the precise terms, but the gist of it is that they agree that certain lots in the land will be severed from the company, as it were, and given over, as they say, to Rooney. One of those lots is said to be a gift. The others are said to be in consideration of a price of $226,000, which is to be paid by Rooney by having his salary from the company docked by $1,500 a month, in circumstances where it was said that he was going to get $2,000 a month. The detail of it, perhaps, it doesn't need to be gone into at this stage, if at all, but it may be relevant because it sows at least the seed for the suggestion that later on there was reason to believe that Rooney had received property from the company for which he had not been paid. No doubt it would be said on the other side that's a mischaracterization of the position.
So which he had not paid?
Forgive me, for which he had not paid, yes. No doubt it would be said on the other side that's a mischaracterization, but I mentioned that aspect of the facts, and we can see from paragraph 60 in the Statement of Facts and Issues that some of the lots were indeed transferred to him. Nothing much then really happens to the company other than that some pre-development work is done, and there's reference in our Statement of Facts and Issues to a report showing that just over $1 million Eastern Caribbean dollars, which is about £300,000 today, had been spent in pre-development work. But nothing much happened for several years. Then, of course, in 1995, there was the volcano, which created an enormous public emergency in Montserrat and made it pretty unpromising as an investment prospect at that stage. And the company simply went to sleep. We mentioned in the Statement of Facts and Issues the New Companies Act, which came into force in 2000. And this is potentially important, my Lord, because it was mentioned in the course of the trial, albeit dismissed by the judge fairly peremptorily. But it's important because it deals with the question of articles of continuance of a company. And can I just ask your Lordship to turn it up very briefly?
Your case runs in opposite directions at this point. One, in respect to the articles, you say it's inconceivable that, or quite conceivable your client didn't know about individual articles, but in respect to the Companies Act, he's absolutely au fait with them.
Well, I didn't. It's not my case, my lord, that there was no case against our client. But these were. I come on to say later on that these were points that if the judge was going to say what he did in fact say, needed to be looked at in rather more detail than the judge in fact did. But I take your lordship's point entirely.
There's a detailed point in the Companies Act which is answered by an equally detailed point in Mr. Knox's skeleton. He says that. You're misconstruing, or at least you're stopping at the wrong point.
Well, yes, I agree. My learned friend relies on a different section. Can I just turn it up very briefly, my lord? It's in the authorities bundle, which is 2632 for those who are following it on the screen, and that's section 362. It says every former Act company shall, within 2 years after the commencement date, apply for the registrar for a certificate of continuance under this Act. The Act commenced on the 1st of January 2000, so that means by the 31st of December 2001 you had to apply for a certificate of continuance.
Sorry, what was the magic date, Mr. Rowe?
31st of December 2001, my Lord.
Thank you very much indeed.
Now, the company was in existence for most of that period. It, in fact, was struck off in September 2001. But we say that doesn't matter for the purposes of this argument or possible argument, because later on, when the company was restored, it was deemed always to have been in existence. And if one then goes from 362 over the page or down to, first of all, 368, I accept skipping over a point my friend makes, but I'll come back to that in a second. We see that at 368, the Act provides that a former Act company, which is to say a company like Providence Estate Limited, incorporated under the previous Act, that does not apply to the registrar for a certificate of continuance within the time limited, therefore, by section 362, shall, on the expiration of the time so limited, be deemed to be continued under this Act, and the model bylaw set out in the regulations shall apply. And the passage that Mellor and Friend rely on, the section Mellor and Friend relies on and says is of importance, is the one immediately before that, previous shares, section 367. A share of a former company issued before the company was continued is presumed to have been issued in compliance with this Act, etc., etc. And I expect that the words he relies on in particular are after the semicolon, and continuance under this Act does not deprive a shareholder of any right or privilege that he claims under an issued share of the company, nor does it relieve him of any liability in respect of an issued share of the company. So I suppose if this had been gone into, the question might have been whether the right of preemption in Article 14b constituted a right or privilege under the share.
Well, but how can it not be?
Because because I think we would submit, or perhaps might have submitted, had we been in a position to do so at the time, that it might be thought to be a slightly strained construction of a privilege under a share. It's not as if...
I would have thought it, in a closed or family company, it's absolutely key that you want to control who your fellow shareholders are. And the right of preemption is it's a matter of law. You don't have to say you would have submitted it to the judge. You submit it to us. But there doesn't seem to be any answer on the face of it.
Well, I see the force of your lordship's point. But what the Act does not do is directly address that issue. The question in those circumstances is whether that section does have the effect that Mellor and Friend contends. But I take your lordship's point.
Yes, turning all companies, closed companies, into effectively companies where you can sell to the outside world. My Lord, transforming the nature of the company.
There is an important point of context which we'll come on to in a bit, which of course is that this was not a company's this was not a civil trial under the terms of the Companies Act. The question, of course, was, as we'll come on to look at in due course, whether the conduct of the defendant was such as to attract the criminal liability, which depended upon dishonesty.
I mean, the difficulty about that, which you will address at some point, is that during the course of the summing up, there was a discussion about specific statutory provisions, claim of right and mistake of fact, and neither there nor at any point during the final speech or indeed in the statement from the dock was there any suggestion of any misapprehension about legal rights of the sort that might be relevant under this statute.
Well, there was certainly no specific assertion by the defendant or on his behalf as to the basis upon which he acted. On the other hand, he did say, and we'll look at this in due course in his doc statement, that essentially he believed he was entitled in law to act as he did. And it's in those circumstances that we say that the judge should at least have engaged.
But the judge, I mean, you can't expect a judge without any suggestion of an evidential nature to have directed a jury on the possibility of some mistake under Section 368, subsection 1, for example.
Well, my lord, we in the abstract, of course not. But in circumstances where the judge does essentially tell the jury that a lot of song and dance has been made about the New Companies Act, but it's irrelevant, the position may be a bit different.
Right.
But no, that's a bit of a diversion, really, from the factual account that I was taking your lordship through briefly. But it gives potentially rise to an argument, as I say, in relation to the effect of the New Companies Act coming into force. The story, as far as the facts are concerned, picks up again in 2007, and I can take this again from the Statement of Facts and Issue. This is paragraph 26 on page 2391, where the evidence was that Mr. Cassell had telephoned Mr. Rooney's brother Peter, who lived in Virginia, and asked him about Rooney's whereabouts, and had said to Peter that he wanted to get in touch with Rooney because he wanted to purchase land in Montserrat from him. And Peter said he didn't know where Rooney was, his brother was, but he would try and get in touch with him, and the evidence was that he had done so. And thereafter, as we'll see in a bit, there is communication between Mr. Cassell and Mr. Rooney's lawyer in Montserrat, who is a gentleman called Hogarth Sargent. Meanwhile, on the 24th of July 2007, the second appellant company is incorporated in Montserrat. And my lord, I didn't go to it, my lord, but there's a short point which, as I've indicated already, the judge made about that, which was that the memorandum of association included amongst the company's objects what the judge said was a competitive object with Providence Estate Limited. If your lordships want to just look in passing at the document itself, it is 172.
Sorry, say it again, please.
172.
172, my lord.
In the core, yeah.
In the core bundle. That's just the certificate of incorporation to give us the date.
The objects clause.
Objects clause, I think we can probably see in volume 5.
Very much.
Perhaps I'm wrong about that. That's
Anyway, it included the holding.
yeah. Anyway, I'll come back.
Long and short of it is, it included the holding of property. Is that right?
I'm sorry.
Long and short of it was that it included the acquisition and holding of.
Yes, it was an old-fashioned objects clause from
Yeah.
drafted in the days when ultra vires was a big issue, and you had to give the company power to do almost anything, and you had to list everything you could possibly think of that a company might want to do, in order to avoid that problem.
It's a rather odd point, this. I mean, Providence was contemplating selling subplots to someone. Is the suggestion it couldn't sell to anyone who was likely to subsell or to on-sell or what? I mean,
Well, the prosecution's point was that it was absolutely obvious to Mr. Cassell that, and to Mr. Wood, that he could not sell his shares to a company whose objects included the acquisition and sale of property, because that would be a breach of Article 14b of the Articles.
well, it's only a breach if they actually engage in.
Well, my lord, I agree. That's our point, but that's not the way it was put by the prosecution. The prosecution case was that, on the face of it, merely by virtue of the presence...
Got to engage in a business in competition with Providence. What is the suggestion that they were engaging in what development like Providence was?
Well, if your lordship had been prosecuting counsel, that might have been the way it might have been put. But the way it in fact was put was a pure legal point.
Yes.
That you don't need to. It wasn't put on the basis of anything that was actually being done. It was put on the basis that the objects clause of Cassell and Lewis Inc. included buying and selling property, and that ipso facto made it a company to which the shares could not be transferred.
Right.
Which is simply obviously a bad point in our submission. But it was thought by the judge to be a good point, and we'll see in due course how the judge directed the jury about that.
It disappears into the background, doesn't it? What the new company in fact set about doing was selling the property which either did or didn't belong to Providence.
Well, I suppose that's right. Your lordship may say it's in the background. I might agree with you, but it's not the way it was put to the jury.
No,
it was
I understand.
Very much in the foreground.
I absolutely understand that.
My lord, we then reach the first of the perhaps the most important documents in the case, which is the transfer of the shares. This is Core Bundle 174. And I think it's an agreed fact that this transfer or this document was executed as it.
Sorry, which page have we gone to? Call 174.
174, my lord.
Yeah.
And we can see it's a transfer of share Walter Wood in consideration of the sum of 810,000 Eastern Caribbean dollars, 300,000 US dollars, paid to me by Cassell and Lewis, do hereby transfer all my shares and interests held in the company Providence Estate Limited to the said Cassell and Lewis, to hold unto the transferee subject to the several conditions in which I hold the same immediately before the execution hereof, and transferee to agree to accept and take the said shares, etc. 30th of July 2007, and we can see, I've already shown you Cassell and Lewis had been incorporated 6 days earlier, and we can see that document was in fact filed at the registrar's office in Montserrat. This is the top right of the page, on the 9th of August 2007. My lord, we can see that the transfer recites the payment of the money. I should say, in fairness, that there doesn't appear to be any direct evidence as to whether the money was or was not paid. Mr. Rooney opined in his evidence, although how this was admissible might be a different question, that in fact it hadn't all been paid, but only $67,000 had been paid. That's at page 713 for your lordship's note. But that may or may not, well, we would say that whether that's right or not doesn't really matter, because the essence of the transfer is that it's immediately effective, and subject to questions of registration, of course, it causes the share to be owned by Mr. Cassell, by Cassell and Lewis Inc. My lord, it's fairly shortly after that the first of the land transactions occurs. And of course, it's a fair point that at this stage, the company, in fact, still doesn't exist in law, because it's been dissolved, and we haven't yet got to that part of the story where the company is restored, though we'll shortly see that that's in train. But the first of the agreements upon which the prosecution relied was the 1st of August 2007, and lordships have that one in the bundle the core bundle beginning at page 177. This is a transfer of one of the parcels to somebody called Dion Weeks, and your lordships can see at 181 that the transfer, or this is a contract of sale, it's signed on behalf of Providence Estate Limited by a director, and I think it's common ground that signature is Mr. Cassell's signature on page 181. And as your lordships will no doubt have seen or picked up, that's the first of a series of documents effecting transfers of the land belonging to Providence Estate Limited. There are contracts of sale, there are deeds of transfer, and there are applications to register the land. And I wasn't proposing to take your lordship through all of those, because it's accepted that they all share a common feature, that they are signed on behalf of Providence Estate Limited by Mr. Cassell, signing in, I think, one cases as director and in one case as president. and it's also accepted that in relation to either all or at any rate a lot of, and it may not matter for present purposes, the transfers, there was evidence that the purchase monies or the deposit, followed in some cases later by more purchase money, was paid to Cassell and Lewis Inc., to the second appellant. Now, of course, as I've said, at this stage, the company in fact still doesn't exist. There's initially an application for administrative restoration, which I can pass over fairly briefly, but it's noted at paragraph 31 of the Statement of Facts and Issues. And that is a document which was signed by Mr. Cassell, describing himself as a lawyer, but as a director of the company. And then there are some discussions between Mr. Rooney and Mr. Wood, which again, I don't think I need to go to the documents, but in the Statement of Facts and Issues we can see that on the 10th of August 2007 there's a conversation between Wood and Rooney. And according to Rooney, this is the evidence Rooney gave at the trial.
Is there any basis on which you can suggest that he was entitled to either sign or describe himself as a director at this stage?
Well, entitled in law, no, I accept not.
I mean, he's a lawyer.
He's a lawyer. I suppose our essential point is he's a lawyer, but he's taken by this point an assignment, a transfer of 60% of the shares in the company.
He hasn't.
Looking at it, forgive me, the company has. You're quite right. Well, his company has.
So,
I accept that doesn't make him a director of the company.
I mean, how can he? The question is, I don't know whether it was ever put as simply as this, but how can he have thought, conceivably, that he was a director?
Well, of course that's the question. But what is important, I submit, is the fact that there is, and this is an important part of the appeal, really, is that there is, at any rate, this transfer of all of Wood's shares.
Yes.
And Wood shares were 60% of the company.
Yeah.
And therefore, I entirely accept, subject to questions as to whether that was, in fact, a transfer which could be followed through by registration of Cassell and Lewis Inc. as the shareholder. In due course, Mr. Cassell was in a position to take control of the company, subject only at that stage to such civil remedies as might have been available to Mr. Rooney.
Yes, but
in respect of unfair prejudice.
Yes. I mean, he's not. He's actually taking steps vis-à-vis the court as well, isn't he? To have the company restored to the register. Anyway, carry on.
No, my lord, he is taking steps. I'll come on in a moment to deal with that. But essentially, we say that it was the only thing that was legally done wrong in the context of the application to restore the company. By that I'm leaving aside the question of Mr. Cassell describing himself as director, and we'll see later on sole beneficial owner of the company. But in legal terms, Mr. Wood would have been entitled to apply for the company to be restored. In fact, as it happened, Mr. Wood didn't make the application. Mr. Cassell made the application, and Mr. Wood provided the supporting affidavit. We'll come on to that in a second. But it was done legally wrongly to that extent. But whether that's an important point is a different matter. How important it is a different matter. But my lord, I was just looking at briefly the conversation which we note at paragraph 32 of the Statement of Facts and Issues, that Wood said that he wanted Rooney to pay him money, and Wood told Rooney that he'd sold the land to Cassell for $300,000. Anyway, the administrative restoration application wasn't pursued, but we then have an application under section 483(6) of the new Companies Act. And my lord, can I just go back to that in this context? That is in the authorities bundle at page 2683. if the company or any member or creditor thereof feels aggrieved by the company having been struck off the register of the court on an application made by the company or a member or creditor before the expiration of 20 years, may, if satisfied that the company was at the time of the striking off carrying on business or an operation or otherwise that it is just the company should be restored to the register, order the name of the company to be restored to the register. And upon a copy of the order being delivered to the registrar for registration, the company is deemed to have continued in existence as if its name had not been struck off. My Lord, it's fair to say that the member may assume importance in this context. That's defined in this Act in section 371, subsection 3, in a way which will be familiar to your Lordship, because it is the same in substance as it is in the Companies Act 2006.
Somebody who's on the register.
Somebody's on the register, my Lord, quite.
Yeah.
It's page 2635,
Yeah.
3713, an incorporator and any other person who agrees to become a member of the company and whose name is entered on the company's register of members, which, of course, is an old rule. I think your Lordship was party to a decision of the Supreme Court. Yes, exactly, and Fastad some while ago about that, tracing the history of that.
Yes, you just look at it's basic company law. You just look at the nominal person on the register.
Yes. So, my Lord, that is the provision under which the application was made. The application itself we can see in the core bundle at page 186. And we can see that it is made over the page at 187, signed by Cassell and Lewis, but at the bottom a file by Warren M. Cassell of Cassell and Lewis on behalf of the applicant. Not quite clear from it who the applicant is, but that may not matter. The grounds of the application are that, 187, there's a point about the court being on vacation and leave being required, and then 2, there are urgent corporate matters to attend to and requires to be, should be the company, no doubt, requires to be in good standing to properly pursue such matters. There is no requirement to give notice the company was struck off the register, etc., etc. And an affidavit in support is referred to. That's not in the core bundle, but you can find it in volume 5, behind tab 89, or if you're looking on the electronic version, it's page 1804. In fact, it's tab 90, but page 1804. Your Lordships will see that Mr. Cassell calls himself the de facto applicant in this matter. He says Mr. Wood is a former director, founder and CEO of Providence Estate Limited. Mr. Wood has transferred all his shares and interest in to Cassell and Lewis, Inc., a company duly incorporated. I am the sole director and beneficial owner of Cassell and Lewis, Inc., which is true. I am also an intended director of Providence Estate Limited.
Well, that's
it. You're about to say that's inconsistent with the transfer that's already been made, saying that he is a director.
Well, it's indicative of the point I made before. He can't have believed he was an actual director.
No, but equally he clearly believes, well, he appears to believe, or at any rate this is consistent with his believing that he is in due course going to become a director, and that he will be in a position to accomplish that in due course.
Do you say this is a sufficiently frank statement of the position?
I say, my Lord, that it is. It's question begging to suggest that it's not, because if there was no intention to either to conspire with Mr. Wood, as we'll see in later the prosecution alleged, to defraud the company or to deceive purchasers, to obtain checks by deception from purchasers. If there was no such intention, then this by itself is perfectly unexceptionable. If one imagines for a moment that the intent behind this had been something quite different, it had been that the intent was, and that they're simply to get the company back onto a footing and then deal differently with Mr. Rooney, then there would have been no obligation to tell the court the full background to it. So that's why I say it's question begging, because clearly, if you start from the premise that this is part of a conspiracy to defraud the company, then it becomes striking that, as the judge mentioned many times in his summing up, there's no mention of Mr. Rooney in the documents. On the other hand, if you admitted the possibility that what was going on here was something different, and that Mr. Cassell, whatever one might think in terms of his commercial sharpness or otherwise, was doing something that he thought was legitimate, then the absence of mention of Mr. Rooney becomes less important.
You mean if he had in mind in due course to preserve Mr. Rooney's beneficial interest, whatever it was, there wasn't any obligation on him to mention him in this affidavit?
Your Lordship puts it much more succinctly than I did.
That's the point, is it?
My Lord, that's precisely the point.
Right.
So, my Lord, that's the affidavit that the first appellant, Mr. Cassell, swore, and then there's another affidavit just before we get to that, so that we're following it in strict chronological order. We can see, and I can pick this up from the statement of facts. There's then quite a long letter that Mr. Cassell wrote to Mr. Rooney's lawyer in Montserrat. This is paragraph 37 of the statement of facts and issues, and you can find the document itself back in the core bundle at page 193. Well, I won't go through all of it, but the essence of it is that Mr. Rooney is proposing to buy, Mr. Cassell rather, is proposing to buy Mr. Rooney out of what he describes as all his interests, brackets, purported or otherwise, in Providence Estate Limited. That's the bottom of page 194. And he explains what he says are considerations over 193, 194. Lordship will no doubt form a view about this letter, and I don't say that it's necessarily the most charming communication that somebody could have sent, but it is consistent, we submit, with Mr. Cassell at that stage seeking to engage with Mr. Rooney in obtaining from Mr. Rooney the minority shareholding in the company which Mr. Rooney had. And you'll see that it culminates with 3 offers, page 194 to 195.
There's a recognition that he was a minority shareholder at that date. Because if you say it's consistent with seeking to obtain his minority shareholding, that is necessarily founded on a recognition that he was a minority shareholder at that date.
I think I'm almost bound to concede that, my Lord, save that the way in which the letter is expressed is that he is described as having an interest, brackets, purported or otherwise. That's bottom of 194 on the right.
Yes, but I mean, it's quite clear from the first 3 paragraphs. There's a recognition that Rooney is there, his lots are still available, the bank hasn't foreclosed on them for the very reason they couldn't find him. Isn't that really all pointing to a recognition that Rooney is still involved?
Well, it starts with you've indicated it, Mr. Rooney is concerned about his interest in the corporation.
Right, there we are.
And he proceeds to make him various offers for it.
Right.
Yes, I mean that's. I suppose I'm succumbing to the advocate's instinct never to concede anything by answering Lord Dawson's question the way I did, my Lord. But I accept that he's seeking.
Sometimes it's good to make a concession.
I accept that point entirely.
Prompted by your own comment on the document that it was consistent with an offer to buy out his minority shareholding.
Yes.
And my ears were alerted to that way you put it in view of what you're about to come to, which is the annual general meeting of which, or not the annual general meeting, the meeting of which no notice was given
Yes.
to Mr. Rooney because he'd been out of touch forever and a day.
If you're in any doubt about the concession, Mr. Rowe, it might be helpful to look at the last line of page 194.
Yeah.
Yes, you will have to
Yes.
sign a share transfer and transfer the property. I accept that, Mark. It's
Okay.
it's.
But this
it's,
is just,
it's, I mean,
this, is
I
just,
think the point
this is just hard-nosed bargaining, you say.
I say that it was that is a possibility which as we'll see in due course, was never admitted to by the judge. But that is a real possibility on the evidence. So, my lord, that's the letter of the 7th of September. We then find that there is a response, or there's some evidence of there having been a response to that, which we can find not in the core bundle, I'm afraid, but in volume 4. And it's behind, I've got the reference right, tab 49, or 1668 if you're following it on the computer. You'll see it's a letter of the 14th of September from Mr. Cassell to Mr. Sargent. In response to your client's refusal to settle below $300,000, I'm prepared to pay the same, but can only do so as follows. And he sets out a schedule leading to complete payment of the whole sum by the 31st of March 2008. I have attached for your perusal draft copies of the promissory note and the transfer of shares for your client's signature before a notary public. I'm not sure those documents were in evidence, but it says the first £50,000 will be dollars rather be paid to you as soon as the executed documents are returned to you. Please let us try and wrap this up before you travel. We'll cover the expense of sending the documents by courier. I await your favourable response.
And attached to it, evidently, is a draft, share transfer.
Yeah. So it's certainly true. Whatever possibility there might have been of any argument about Mr. Rooney not being a shareholder, I entirely accept that he was being treated as if he was somebody who needed to make a share transfer. I should say, in fairness, that on this point, although the statement of facts, the agreed statement of facts, says that Sargent told the first appellant that Rooney would not settle with him for less than $300,000, which we I think both have taken from the first clause of the first sentence in response to your refusal to settle, your client's refusal to settle below $300,000. Mr. Rooney himself, in evidence, claimed that he had made no such counter-offer and that he wasn't interested in selling the shares. That doesn't seem to have been a point that surfaced again. So we don't know what the real position is. But certainly, as at this stage, that's on the documentary evidence, that's the position that Mr. Rooney is taking. It's also fair to say that there is no evidence of a response to this letter, favourable or otherwise, from Mr. Rooney. Then we come on to the next part of the application to restore the company. I said earlier that I took your lordships earlier to the provision of the Act that says that it's a member or creditor who can apply to restore the company. So it really should have been Mr. Wood or Mr. Rooney, but for obvious reasons he wasn't interested in doing that at this stage, who should have been restoring the company. But what we do have is not an application from Mr. Wood, but an affidavit from Mr. Wood, and that's in volume 5, behind tab 91. At page 1807. And your lordships will see that Mr. Wood, in the affidavit, says that he is a director, founder, and former shareholder of Providence Estate Limited. He says, I have recently sold all my shares and interests to Cassell and Lewis, Inc. Doesn't incidentally say that he is the sole shareholder of the company. A company duly incorporated, etc., etc. Copy has been filed. And he says at paragraph 5, as a director of the company, I support and authorise this application to restore the company to the register in order to complete my transfer of shares and to allow Mr. Cassell to be appointed as a director in my place and allow him to proceed with the real estate business of the company.
Was there any evidence about who drafted this?
I don't recall expressly, but it looks as if it was drafted by. I mean, it wasn't. I don't think it was suggested it was other than a genuine document. I think I assume its draftsman was Mr. Cassell.
Yes.
And of course, it's fair to point out, as no doubt my friend will, and as the judge several times did, that Mr. Rooney is not mentioned in this affidavit. Well, Lord, the effect of that affidavit, the application, and Mr. Cassell's affidavit was that on the 21st of September 2007, the court made an order restoring the company to the register, which, as I've indicated, has the effect that the company is deemed to have continued in existence as if its name had not been struck off. And we set out in the statement of facts and issues, and I won't go to them at this stage. My Lord, my learned friend, if he wishes to, will go to it in due course. We set out a series of other documents signed, in fact, on the same date, a series of other transfers of land to, or agreements for, I think these are all actual transfers rather than agreements to transfer that are signed on that date. There is also at paragraph 42 at this point that on the 22nd of September 2007, the application to restore the company to the register was faxed by Sargent, who was Rooney's lawyer, as we've seen, to Mr. Rooney.
But just going back from the 22nd of September to the previous day, we've got the important resolution of the members, haven't we?
Well, I haven't gone to that yet, my Lord, because
I thought you were following a chronology.
I am, my Lord, but the reason I haven't gone to it yet is because that document doesn't get. I want to explain the provenance of that document and the circumstances in which it came to be registered with the company's register, and that's a little bit later on.
Right.
But there is. Well, I don't recall whether the evidence is that the document that you're referring to was prepared on the date it bears, or whether it was prepared later on. But it was certainly filed at company's registry later on, and that's why I was going to come back to that in due course.
Mrs. Lynch, who was, or Miss Lynch.
Mr. Lynch, yes.
Sorry?
I think it is Mr. Lynch, I think, yes.
Miss Lynch. Well, he was doing your client's bidding, was he not?
Yes.
And it would be fair to infer...
It's Miss, forgive me.
Miss.
Miss, that she prepared this document on his instructions.
Yes.
Therefore, if it is a truthful document, there was a purported meeting of directors on the 21st of September 2007.
Yes, I agree, so perhaps I should deal with it.
At a meeting of which Rooney was not given notice.
Yes. My Lord, I accept that, and perhaps I should deal with it now. And I think from recollection, I'm sure my learned friend will take you to it in due course if I'm wrong about this, but her evidence was that there was such a meeting, or a purported meeting, as far as it was a shareholders' meeting. But the document itself, we can see at page 207 in the core bundle. This is the document headed Resolution of Members, 21st September 2007. The requirement for notice of the meeting was waived for the purpose of an extraordinary general meeting and for the purpose of the agenda item relating to the removal of the director, Owen Martin Rooney. and Walter A. Wood, the former refusing to return to Montserrat and not having made any contact with the members of the company for several years.
Now, this was the man with whom he'd been in correspondence up to a week before.
That, my lord, that is right. Whether it's inaccurate to say that he had not been in contact with members of the company for several years, and I appreciate I may be splitting hairs here, maybe a different point.
Where is it referred to in your statement of facts and issues, actually?
My lord, it's referred to at paragraph 47, 2397.
Oh, yes.
We put it there because that's when it was filed at the registry.
Yeah, quite.
43.
I'm sorry, my lord.
47.
47.
Paragraph 43 of the statement of facts. Anyway, 24th of September.
Yes, no, not quite, my lord. No, what happened was that there was, on the 24th of September, there was a notice of change of directors. That's the document 205 in the core bundle.
Yes.
And
I see.
that
The
simply
meeting's
gives
filed
notice
later.
of the change of directors. And then subsequently, I think we set this out, I think then there is there's a query from the registrar. This is paragraph 46 of our statement of facts and issues. The registrar saying that that what needs to be done is that a copy of the resolution showing the change of directors from 2 to 1 needs to be filed. That didn't, in fact, happen until 27th of November. So the sequence in that is therefore 24th September, the notice of change is filed.
Now,
And then subsequently the resolution is put in.
was any explanation ever proffered by your client in his doc statement or through cross-examination or in his counsel's closing submissions why no notice was given to Mr. Rooney of that meeting?
No.
No.
Or indeed for why Rooney was described as not having made any contact with a member of the companies for several years. Was simply an absence of...
There was an absence of
Simply
evidence
wasn't
on
addressed.
there was an absence of evidence on that point.
I mean,
we'll come on. Sorry.
Sorry, I do apologise.
No.
Just going back to the dating, I mean, wouldn't one have to be rather optimistic to think that this resolution was actually made on the 21st of September? I mean, the reality is that it emerged, I think, in December, as you say, and that appears from the stamp at the bottom and probably from the writing at the stamp at the top and the writing at the bottom. The remarkable coincidence it emerged just after the Registrar of Companies had been saying on the 27th of November that she'd like to see a resolution. And it's a rather different effect to what is we know happened on the, I think, 24th of September, which was the document at 2:05 was filed, giving notice of change of directors and notifying the appointment of Warren Cassell. There's no suggestion that his appointment was being backdated, even if that's possible. And there's no suggestion of well, no, that's the real point. Those are the points.
Yes. Well, my lord, the notice itself refers to the date of the 21st of September.
Yes, of course. But what I'm saying is we've got a nice-looking document at page 207, which Lord Toulson's been drawing attention to, and we've got some evidence which we might look at if it's relevant, but I'm a bit sceptical at the moment about the idea that this document of the 21st of September had any existence until the Registrar of Companies said she needed a document.
Well, but one understands why Your Lordship says that. What's clear in any event, I quite accept, is that already by this stage there had been transfers of property, and that continued to occur. My Lord, just to complete the...
I'm awfully sorry to do this to you, Mr.
No, not at all, my
While I'm looking at 207, is there any significance in paragraph 2 of the resolution that Mr. Cassell's appointment as a director is said to be with immediate effect from the 1st of July.
Well, my lord, I suppose the significance of that may be that goes back before the first of the sales, because that was on the 1st of August.
It's not a date that we've come across otherwise, I don't think.
No, I think that's right.
Presumably a purported sort of attempt to ratify.
Yes, it's not in the document at 205, but maybe it wouldn't have to be.
Yes. I mean, well, this is the. It raises the point about what conceivably might have been the defence that wasn't dealt with by the judge, but that could perhaps have been mentioned to the jury, or some aspects of this could have been mentioned to the jury, which is that if Mr. Cassell had a genuine belief that he was entitled, in the light of all the circumstances, the 60-40 split in the company, the evidently difficult relations between the two, somewhat estranged relations between the two shareholders, and the fact that he'd been able to persuade the majority shareholder to pay him, to transfer to him the majority shares, and he was in negotiations with Mr. Wood. That if and I accept, of course,
with
the
Mr. Rooney.
I'm sorry.
I think you said he was in negotiation with Mr. Wood. It was Mr. Rooney.
Forgive me, Mr. Rooney. I spoke wrongly. Mr. Rooney. I agree. I mean, the point is that if Mr. Rooney had responded to that letter or to the offer about £300,000 by saying, "Done, here's the transfer, and I'll await payment of your money," then, of course, none of this would ever have happened, because the company would indeed all have become Mr. Cassell's or Cassell and Lewis's. Of course, that didn't happen. I quite accept that.
It's a pretty double-edged sword, that one, isn't it? Yes. He realised that he had to get Rooney's agreement before he could make the assertions that he did.
Well, my lord, I accept that, and I accept that he had already purported to sell property on behalf of the company before while he was still dealing with Mr. Rooney in that context. I accept that.
In due course, the charges, once they'd been put right, less said about the first document, the better, but once they'd been put right, the charges were double-barreled, weren't they? Leave the money laundering on one side. The
Yes.
charges were double-barreled. There was a conspiracy to defraud Rooney, and there was deception of the purchasers.
Yes.
Is that right? Basically.
Essentially, my lord, that's right.
Yeah.
Yes.
And there's no suggestion at any stage that any of the purchasers had any idea that Mr. Rooney existed. I don't think.
No.
No. Okay.
No.
Just looking at the document on 207, I see it says not just he's going to be appointed a director with immediate effect from the 1st of July, it goes on, and the secretary is directed to prepare and file the appropriate notice of change of directors with the company's registrar. Well, it's noticeable that the notice of directors was filed very soon after the 21st of September and doesn't refer to appointment from the 1st of July. Again, I mean, if this document, the resolution, was prepared later, it seems to be prepared with a disregard for the actual facts, both as regards the statement that Rooney had failed to return to Montserrat and not made any contact for several years, and secondly, paragraph 2 is really trying to rewrite history in a way which is rather unrealistic, isn't it?
Well, one notes your lordship's observations about.
Well, I'm just trying.
I
mean, what is your case about when it was actually prepared? Are you saying it was prepared on or about the 21st of September?
Yes.
You are.
You haven't got a positive case, to be fair.
I suppose that's right. I haven't got at trial. You're right. You're right. What am I saying?
All you can say is that it might have been.
It might have been. Yes, that's right.
Right.
I should have resisted the temptation to give such a straight answer to your lordship's question.
Thank you. Right. Let's remember where we are.
Yes. Yes, I've just asked my learned friend to find the evidence of Meredith Lynch on this point, but
Right, let's go on.
anyway, my lord. So there we are. The next thing I wanted to mention, having dealt with that, is the action that was started in the United States by Mr. Rooney. And, my lord, we can pick that up from volume 5 in the bundle at tab 59. Which is page 1709. Lord, this document doesn't give you the date those proceedings were started, but it's common ground that they started on the 23rd of May 2008. And they were proceedings by Mr. Rooney against Walter Wood et al. And the et al. Were the appellants. And it's common ground, too, that the appellants never submitted to the jurisdiction of the Virginia court.
But had notice?
I'll have to check, my lord.
Okay.
I don't recall.
Now, can you help on one thing? Divider 55, page 1688. This is from Mr. Rooney to his lawyer. It's the 20th of March, 2008. And it says that Cassell, second paragraph, was served by the bailiff in Montserrat on the 4th December 2007. One of the exhibits to our complaint was second meeting of the board of directors, which said lots 26, 27 were mine, etc., etc. Despite being served and knowing there was a suit pending against him in Virginia, the land registry records that Cassell received payment on $199,000 on 11th July 2008 from Mr. Krause, and so on. In other words, Cassell continued to dispose of my assets even when he knew there was a lawsuit pending against him, indicative of total contempt for the Virginia court proceedings. Now, there seems to be a bit of a gap in the documents. I couldn't find what was this, these proceedings which were served by the bailiff in Montserrat in December 2007. Can you help?
They were the Virginia proceedings.
Yeah.
They were issued on, my lord, they were issued on the 15th of November. We don't have the original proceedings. They're issued on the 15th of November, and the evidence was that they were served quite a few times at the end of November and beginning of December on Cassell.
Well, if that's so, the potential significance of that is before the transfer, for example, to Mr. Osborne.
Yes.
Joel Osborne.
Some of the transfers, I can't remember which.
Yeah.
Several. But my lords, what we do have is the amended proceedings, which were issued in May, or rather the amended form of the proceedings
So
issued in May.
So the ones we were shown are just an amendment.
Yes, I think there's a...
Where is the actual evidence that proceedings have been served on him in December, and possibly on other days as well, so that he was cognizant of the issues in the Virginia proceedings at the time when these later purported sales were made? Where's the evidence?
Well, Mr. Rooney gives evidence of that. I'm not sure that Mr. Rooney was the man who served them, but he certainly does say they were served.
Well, I dare say he did, but he couldn't give any reliable evidence on the topic, could he?
Well, my lord, I better just check the documents. I haven't. Yes. I've certainly got references from Rooney's evidence.
Well, it depends what he was saying. He may have. Yes, it depends what he was saying. But if he was saying, as I suppose he just might have been, I had a document which showed that he was served.
I've seen that.
And if nobody then contradicted him, then that may be different.
Yeah.
But otherwise, it simply wouldn't be
admissible on its own. Well, unless he had some means of knowing.
Yeah.
So, my Lord, I'm grateful to my learned friend, and I accept entirely that document at 1688 certainly appears to provide some evidence, query whether it was admissible evidence in a criminal trial, about the knowledge of Mr. Cassell of the proceedings in Virginia. But the point that of course, we make about the proceedings in Virginia is not doesn't turn on his knowledge or otherwise of the proceedings. The point that we make about the proceedings in Virginia is that he didn't submit to the jurisdiction of the Virginia court.
No, but the potential significance is his awareness of the points being raised in those proceedings, if it be the case that having had those brought to his attention in a jurisdiction where he declined to appear, he nevertheless continued to enter into dealings in the land.
Yes. Well, again, your lordship makes points that, makes points which might have been made by the prosecution, but as we shall see in due course when we look at the summing up, again, that wasn't the way that it was put at the trial. The Virginia proceedings were brought into the prosecution case in an altogether more direct way, which is essentially to say to the jury, as we'll see, look, this is what the Virginia court found. Hinting very strongly, we say, that therefore you should find the same thing, which of course is, we say is completely unacceptable.
Well, that's certainly what the judge said. The prosecuting counsel was saying, look, he knew, wasn't she?
Well, that wasn't the only thing she was saying, my lord, but can I come back to that?
Come to it in due course.
But just to go back to where I was, at 1709, the order itself of the 3rd of October of the court in Virginia is an order made on an application for default judgment, which of course is consistent with Mr. Cassell and Cassell and Lewis having not responded to the proceedings. And it grants declaratory relief to the effect that the purchase of Walter Wood's 60% interest in the shares in Providence Estate Limited is null and void. And then it goes on to say, count 3, civil conspiracy. Judgment is hereby entered against Cassell and Cassell and Lewis, Inc., jointly and severally, in the amount of, slightly oddly drafted, and then over the page B, count 5, intentional interference with contract. Judgment is hereby entered against Cassell and Lewis, Inc., jointly and severally, in the amount of $3,688,157. And then there's further a judgment for an account in relation to all activities and all funds since the 1st of January 2007. So that takes us to October 2008. We know that the first appellant, Mr. Cassell, was arrested on the 4th of November 2008.
Just thinking about it, Mr. I'm awfully sorry. There's nothing more infuriating, but if I don't say it now, it'll be too late. This is a default judgment, isn't it?
Yes.
Default of appearance.
Yes.
Well, unless the rules are very different in Virginia from anywhere else, they'd have required evidence of service, wouldn't they?
You would have thought so. Yeah.
Okay.
My Lord, there's one other thing I wanted to mention in the chronology before I then turn to the summing up and seek to make good our points about the way in which the summing up was not fair, and that is to point out something that Mr. Cassell said in his unsworn statement. My Lord, this is volume 3, tab 28. Line, page 1281. Sorry, my Lord, I think that's a wrong reference that I've given you. Give me one moment.
That's That's the doc statement, isn't it?
That's what I'm trying to find. I'm sorry if I've gone astray. One moment.
I see I've noticed just in relation to the point raised by Lord Hughes about service, the certificate of service is at page 1720.
That's the July service. This is the I think this is the amended. That's the amended complaint.
Yeah.
Yes, but by parity, presumably, they would have insisted on service of the original
I
document.
thought so.
One would so infer. That's why I would be helpful to know whether that document is properly in evidence, or whether we simply have to
It doesn't help.
speculate.
That document doesn't help on whether
This
the
one
service
doesn't
in
help.
December or not.
No.
Yeah. No, my Lord, forgive me, the further point I wanted to make, it is 1281. This is the doc statement. And it's just this point that Mr. Cassell said at the top of that page, when the Attorney General's office asked the registrar to hold off the transfers, we filed an action in the High Court arguing that there was no basis to prevent the transfers. The court adjourned the application, and it was then that they made an arrest within 2 days of returning to court. They then arrested Warren Cassell. He's talking about himself in the third person. Within 2 days before I returned to court, about 2 days before, then came back to court and said, we have a basis now. It is now a criminal matter. It was then that the court ordered that the transfers be held off until the criminal matters were determined. And he goes on to say there was no false representation made, etc., etc. But the point is that is, I accept that wasn't in evidence as such, but it was in his statement that he had in fact commenced proceedings himself in court in circumstances where the Attorney General had sought, no doubt at that stage, having been in discussions with those who were about to arrest Mr. Cassell, had sought to have those transfers stopped, and he went to court, he says in his unsworn statement, to have that process stopped so that the transfers could go ahead.
What's that got to do with it?
My Lord, it's when I come back later on to make my complaints about things the judge might have mentioned to the jury, were he inclined to say anything in favour of Mr. Cassell, that might have been one of them, because it might arguably be thought to be inconsistent with the charges that Mr. Cassell had, he would say, such confidence in the fact that what he was doing was appropriate, that he actually applied to the High Court to seek to have the transfers not stopped by the Attorney General. It goes no further than that, but it's a point that might have been made. So, my Lord, I think that completes, perhaps less briefly than I had intended, the trek through the
It was very helpful.
facts. But I hope it was helpful, my Lord. But it's sometimes easy to see the things in the documents themselves. The way the case was put, I want to refer, before I go to summing up, just refer briefly to what was said in a couple of points in the respondent's closing speech. And this touches partly on the Articles of Association and partly on the point about the Virginia judgment. My Lord, here we're in volume 3 at where we've just been, at page 1286.
Starts 1282, is that right?
Lord, I think that's right.
Thank you.
Can you just help me on one point? Of
course.
What was the name of the judge?
Redhead.
It was,
Mr. Justice Redhead.
and he came from a different jurisdiction, is that right?
I believe so.
Yes, he was an advocate.
Where is he from?
Originally from Bermuda. He served as a High Court judge, as retired, and came as acting.
Oh, I see. I gather he was a retired judge of the Court of Appeal of the Eastern Caribbean, acting as a puisne judge for the purposes of this trial.
Thank you.
My Lord, the passage we refer to, we take this, we mentioned this in the Statement of Facts and Issues, but it's 1286, where the speech by counsel for the prosecution includes fact that the statement that the first thing you do, she says, when you realise there's a name of a company is you go to the Articles of Association. This is about halfway down 1286, line 14, your Lordship sees that. And you read them, that's the first thing you look at, it's very affordable, and you go and look at the company document, costs 20 Eastern Caribbean dollars, you're entitled to make the conclusions that from that January phone call, he knew all that was required of him, and he can't say he didn't know because he's a lawyer, and he has to know the legal position when he's going to deal with land. And it's, well, at that point that we really emphasise, he can't say he didn't know because he was a lawyer, is the way it's put by the prosecution. And I don't in itself necessarily complain very greatly about that, because one can see there may be some force in saying he's a lawyer, so he might be expected to know more about legal documents than a non-lawyer. But it then becomes transformed by the judge into something quite different in due course, as we shall see.
But all this is prefaced in Crown Counsel's speech, isn't it? From 1283, 1284 really onwards. Line 5. You must decide whether either or both of them chose to ignore the law, whether either or both acted dishonestly, committing fraud. Top of the next page, did they know the legal position? Knowing it, did they deliberately ignore the law, go on to commit fraud? I'm going to address that very central question. She got it right.
Yes. Yes, although she... she put it in fairly strong terms when it comes to the, which is not necessarily wrong, but it needs to be borne in mind by the judge later on. when she put it in fairly strong terms, when she said in relation to the clause in the Articles of Association upon which the prosecution relied, that it was staring them right in the face. This is 1292.
Yeah.
He says, she says rather, line 7 onwards, it's in their words, nobody forced them to draft the agreement in the way it was, but it's clear from the words that Cassell and Lewis don't just take over the shares and the interest, it is subject to every single condition in the Articles and Memorandum of Association, because members of the jury, these are the conditions in which he held them immediately before execution. You will know some of them by now. If you want to sell your shares, offer it to the other director first. Isn't it astonishing that two people who make an agreement clearly in the light of an unlawful clause? Quite sure what she means by that, but they signed up to a piece of illegality. It is staring them right in the face. And she goes on to say, you say in your document, etc., etc. Could they really have forgotten the conditions, or is it not that they have begun here as a lawyer learned in the law? Yeah. He drafts this very section from the very law, and then he chooses to completely ignore it. It is a characteristic of the criminality that we say went on in this case. It is not worth the paper it is written on, and then that neatly follows into the other reason I wanted to go to this part of the speech, because she then says, you see, members of the jury, you didn't need really the Virginia court judgment to tell you, sensible, normal, common sense people, that this is a piece of illegality, but we have got the Virginia order, and it says what? Null and void. It was null and void the day they drafted it. They signed off on something and then went and did something completely unlawful. Nothing was transferred. That's what null and void means. Nothing was transferred, no shares, no interests. And then she goes on to make the point about, which again we say is a thoroughly bad point, about the objects clause. She says, we mustn't lose sight of this. If you have a company to which you are transferring shares has a competing interest, it wouldn't be right for that person to become a shareholder. That's what the Articles of Association of PEL says. That is a condition that Cassell and Lewis took, that no person should be registered as a shareholder who is engaged in a business in competition with the company. You will have access to a copy of Warren Cassell's company's date of incorporation, etc. And she goes on, and then at line 3, the objects in the Articles of Association say, etc., to acquire and deal with any property, real or personal. So, there are a variety of points bound up in that, my Lord, and you'll see what they are. But certainly in relation to the Articles of Association and 14b, we see that counsel for the prosecution essentially says to the jury that it was staring them in the face, and that's why I took your Lordship to the document itself. Query whether that's necessarily a statement by the prosecution which requires no tempering by the judge. And in relation to the Virginia judgment, she pretty much in terms tells them that they don't need to exercise their own judgment because the Virginia court has done it for them by telling them that the transfer of the shares, which of course is the start of the whole process, is null and void. And later on, quite a lot later on in the speech, she also refers to the conspiracy charge. This is page 1319. The memorandum says minimum of 2. It's halfway down the page, line 12. She's talking here about the number of directors. And she's referring to what we discussed earlier, the reference to the need to file the resolution that the registrar had pointed out in late 2007. But she says, too, the Virginia court, if he was in any doubt, the Virginia court ruling put him right. What you just did with the shares was null and void. The civil conspiracy was found in favour of Rooney. So I agree that in that context, as has already been pointed out, she's perhaps more saying not that you should be bound by what the Virginia court did, but that the Virginia court was a warning to Mr. Rooney. But at the same time, she gets in the fact that the Virginia court has already found that there's been a conspiracy between Mr. Wood and Mr. Rooney, which might be thought to be a bit unfortunate when that was the very issue which the jury were charged with deciding. Mr. Wood and Mr. Cassell, rather. My Lord, that's what's said in the prosecution's speech about this. There's a short point about company law where she simply dismisses any suggestion that the new Companies Act is of any relevance. I touch on that fairly lightly because I entirely take your Lordship's point that there was no systematic attempt by the defence at trial to rely upon the New Companies Act. But it's, for your Lordship's note, it's 1327, where she says, we say simply that members, there isn't any basis to say that Warren Cassell was a director. The company law that presently governs Montserrat is more important and takes precedence to the Articles of Association. We say that too is wrong and is in error. My Lord, I wanted then just to look briefly at the doc statement. I've taken
everything you've heard is dictated by the company law documents you've heard about, i.e. the contract governs.
Yes.
And, I mean, she's right on that, isn't she? Well, we've been through that hoop.
Yes. My Lord, I wanted then to take you briefly to what was said both by Mr. Cassell on his own behalf and on behalf of Cassell and Lewis, and by his counsel in the closing speech. The first of those, we go back to 1279. And he says at the bottom of that page, sometime in 2007, Cassell and Lewis Inc. acquired from Walter Wood all his shares and interest he possessed. Mr. Wood indicated he wanted to have nothing to do with Providence Estate or Montserrat. He wanted to part with his share. Walter Wood and I, that's Walter Wood and Cassell and Lewis, had no agreement to defraud Owen Rooney. The only discussion agreement we had was about the transfer of shares from Walter Wood to Cassell and Lewis. Neither was there any intention to do any such thing. Everything was documented and was above board. I never told Walter Wood that Owen Rooney was dead. And he then goes on to talk about the process of the restoration. And then line 10, it is now a criminal matter. It was then the court ordered that the transfers be held off. Your Lordship's seen this already. At no time was any false representation made. All the government agencies involved have documents supporting authority to act. Not once did any of those agencies say to us, we do not accept your documents, you have no authority to act. Based on our understanding of the law, Warren Cassell was always a director of Providence Estate Limited, and there was no conspiracy to defraud, neither was there any concealing of any funds. And I entirely accept that it is not a point in our favour that he did not expand upon that statement, but that is what he said. And in the closing speech for the defence, there wasn't, as I've already accepted, any real expansion upon that, but there are just these two very brief points that we highlight from that closing speech. 1334. Line 14, look at the evidence, ladies and gentlemen of the jury. Does it make sense that a learned attorney would be moving from one government agency to another while committing criminal acts? Does that really make sense?
Yes, he too is hanging it correctly on the question of dishonesty, isn't he? Top three lines, 1334.
Yes.
Yeah.
Crown must prove beyond a reasonable doubt that there was dishonesty here. And then there's just this point, my Lord, in relation to the Virginia judgment. He mentions this at page 1340. And he criticises the prosecution here. He says, Mr. Rooney waived the Virginia judgment and waive it, and the prosecution has relied on that Virginia judgment. When the prosecution asked you to consider that the Virginia court was saying that whatever Wood and Cassell and Lewis did was a nullity. Look at the judgment, ladies and gentlemen of the jury, and you will realise that those issues were never determined on the merit. It was a result of the default judgment. The second question then was there any attempt made to enforce that judgment in Montserrat? Now, you might expect that the judge would say at that point, hang on a minute, members of the jury, you shouldn't be looking at the judgment at all. It's certainly not for the purposes of deciding whether you agree with the American court. But far from that, the judge says, are you saying a default judgment is of no validity? And counsel backs down. No, I'm not saying that at all. I'm not saying that at all, just asking the jury to make an observation. So we complain that at that point the judge essentially tells defence counsel off for making what, in fact, was approaching a pretty fair point. So, my Lord, that's all I want to say about the, before I then turn to summing up itself. Can I take you then to that, my Lord? That's volume 4. And it starts at around page 1347, I think, right at the beginning of volume 4. It starts off innocuously enough with standard directions about division of functions and burden of proof and so on and so forth. But I want then to pick it up, if I may, my Lord. I should say, in fairness to my friend, it's 1351, not that my friend places much reliance on it, but 1351, the judge says, during this summation I may make observations on the facts, which is a bit of an understatement, as we'll come on to see. The observations I make on the facts are my observations, and you are at liberty to reject my observation on the facts if they do not appeal to your sense of reason. But he then gets into the meat of it, and I appreciate your lordships have looked at this, and I'll take it as briefly as I can, but it is perhaps important to set it all in context. Picking it up at 1362, he says, bottom of that page, the Articles of Association, Memorandum and Articles of Association was the genesis, if I may call it, of the unlawful act of the accused, Cassell and Owen Rooney. So not the genesis of what the prosecution say was the unlawful act, the genesis of the unlawful act. Accused Cassell restoration of PL, in other words, to bring PL back to life, because once it was struck off, etc., someone had to make an application. Cassell, I may say, in law was not a director. He was never a director. He's never been a director of the company, and this is my address to you on the law. So far as the law is concerned, he has never been a director and as a legal director. That may be the transcript's gone slightly wrong. I accept he was entitled to tell the jury that in law Mr. Cassell did not become a director. But he goes on then to say he had no legal authority for so doing, reinstating the company, to bring the company back to life. And he asked the jury to consider an instance that one of you know of a company, you don't have any authority to restore it. But he then says you have no authority, and if you do so, you will be acting unlawfully. So he immediately conflates the various different questions that arose in this case with respect to the application to restore. Because it might be right that, as a matter of company law, Mr. Cassell or Cassell and Lewis Inc. had no standing to make an application to reinstate Providence Estate Limited to the register, so that to that extent it's right to say that was an unlawful act. But of course the question for the jury, in the light of the way that the case was being put by the Crown, was whether there was a conspiracy on this part of it between Mr. Cassell and Mr. Wood, and between the company and Mr. Wood, to defraud and to say simply that, well, you will be acting unlawfully is highly dangerous, because it essentially directs the jury, or gives the jury reason to think they're being directed, that the answer to that question must be yes, that there is fraud going on, there is a conspiracy going on.
It starts at 1361, if you look at the bottom of the page. What he gets wrong is he starts with an entirely conventional direction that a conspiracy is an agreement to do an unlawful act.
Yes.
And then he moves from that to the assumption that as long as you prove an unlawful act, you've proved a conspiracy to defraud, which of course you haven't.
Yes. Yes. Well, my Lord, your Lordship picks up another passage. It's one of the features of this case that there is on this aspect of the case, there is from Defence Counsel's point of view a bit of an embarrassment of riches in this summing up when it comes to points that the judge took which were unfair. But my Lord, if I then pick it up over at 1365, he's talking here about the application to restore, and I made the point earlier that it would have been in itself, by itself, the failure to mention Mr. Rooney did not make it unlawful as a matter of company law. But the judge says line 16, 1365, he never mentions Rooney, because to mention Rooney in this document would have put the court on notice there is someone else. There is another director. And if the court had known the truth, all the facts in this case, I am confident that no court would grant that application that the accused made. No court, I say with confidence, knowing the true situation, would ever grant that application which the accused was seeking. And then he goes on to say, secondly, Walter Wood in the Articles of Association know. Not the Articles of Association say, but Walter Wood knows that in order for him to legitimately sell his shares to the accused, he had to first offer those shares to his partner, Owen Rooney. He did not do so. Another thing he ought to know, that Warren Cassell had no authority to restore the company. And here you may find, this is line 7, and you may draw ample inferences. Here is an agreement to do something unlawful between him, the accused, the company, and Walter Wood. As I said, it's important you consider the affidavit of Walter Wood in support of Warren Cassell's application to restore PEL to the Register of Company. In my view, that application is cleverly crafted and was meant to deceive anyone who should rely on it, because he omitted to mention a very important fact. That is, Owen Rooney is a director of PEL. In a nutshell, Walter Wood is director, which is true that he is selling all his interest to Cassell and Lewis. This he could not do, as I said, lawfully, because Article 14b of the Articles of Association reads, and he sets it out, taking an entirely bad point about competition, and he goes on then over the page, having summarised Article 14b, line 8, nothing like that happened, and Walter Wood ought to know that because he is a founding member of the company. He knows the Articles of Association. Cassell ought to know because he is a lawyer. And I will say to you, when you are judging this case, you judge him as you judge any other person. But when it comes to knowledge, then you look at particular. He, being a lawyer, ought to know, because if he's buying shares, it'll be very prudent, etc., etc. And down at the bottom of the page, again, 24, a lawyer ought to know. And then over the page, 3, even if his shares were legally transferred to Warren Cassell and his company, Warren Cassell did not have the authority to make the application to restore PEL to the Register of Companies, and Wood must have known that. And then he goes down further. What's interesting in Mr. Wood's sworn statement, in my view, is that he said he is a director, not the director. However, he never mentioned Rooney as the other director. He's studiously mentioning, probably means not mentioning Rooney's name, in my view. And then, rather ineffectually, after all that, your lordships may think, he says, again, that is my comments on the evidence, if it is for you to accept or reject it. But, my lord, we say about not only was that beyond the bounds of proper comment, it was also pretty confusing to the jury on this question of Mr. Cassell being a lawyer, because one asks, how are the jury supposed to, what are the jury supposed to make of the suggestion that Mr. Cassell should be judged by different standards because he's a lawyer? How is the jury supposed to know what a lawyer does or doesn't know about the Articles of Association of a company? There's no guidance given to them on that. They're simply invited to conclude that he must have known that everything that he was doing was wholly unlawful at that stage because he's a lawyer.
Well, he'd be entitled to say, wouldn't he, when you're asking whether he knew, you're entitled to take into account the fact that he's a lawyer who deals with company affairs day in, day out. You could say that, couldn't you?
You could say that had that been the evidence. I'm not sure that the evidence went quite as high
All right.
as that, my lord.
But what you can't say is that he ought to know.
No. Or indeed, as we'll come on to see later, that he is and law deemed to know, which is what the judge goes on to say.
Yes.
My lord, there's then at line 7 on page 1369, this observation by the judge, because there had been some reference to the fact that it was an old company, you may recall a lot of song and dance was made about the fact that PL was an old company and under the New Companies Act was passed, etc., etc. Let me say to you, the new Act did not in any way and could not in any way affect the position of PEL as far as directors were concerned, because the new Act did not change all existing companies and they could not do this, that all directors are hereby revoked, etc., etc., etc. I'll come back to deal with that in due course when we raise our secondary complaint about matters that were not referred to. But then the judge gets back to the application to the registrar, to the court to restore the company to the register at the bottom of 1371. Once again, I return, this is line 21, to Warren Cassell's application to the court to restore PEL to the register of companies. And he refers to the affidavit. He makes again the point that there was no mention of Mr. Rooney. As I told you, and let me remind you, in other words, affidavit in support of Cassell's application to reinstate PEL, I'm down to line 7 here, Wood's affidavit bears no mention of either Rooney, bearing in mind that Providence Estate Limited, although Wood did not say this, he is the sole director of the company, but rather a director. This is why I said that this affidavit was cleverly crafted. And then the disclaimer again, this is an observation I make. You may reject it if it does not appeal to your reason. If he had mentioned Rooney, this would have put the judge on notice. And again, at line 20, I say this without any doubt. The judge could not have seen the Memorandum of Articles of Association because no judge, in my view, seeing the Memorandum of Articles of Association could have granted Warren Cassell's application to restore PEL to the register. Which, incidentally, is just wrong as a matter of law in any event. That assertion by itself, if what the judge means is somehow in law that couldn't have happened, and that therefore the application was defective for that reason. But there it is. Then we go over to, if I may, to page 1373 on the opposite page. He talks about the contact that was we heard about earlier with Mr. Rooney's brother. Almost at the end of that page, 23, in January 2007, he must have known that Owen Rooney was alive and to make an application to the court to reinstate PEL to the register of companies, not mentioning Rooney's name. You may think it was an attempt to deceive the court. Well, again, we say by this point, it's not so much you may think as you should think, is the gist of what is being said. And then I go on, if I may, to, skipping a few pages, to 1379. And this is another point about him being a lawyer, 23, bottom of that page. So on the 7th of September 2007, there would have been no doubt that he knew of Rooney's interests. He, that's Mr. Cassell. He must have known that Rooney was a director. I say to you that you judge Warren Cassell, as I've told you, as you judge any other individual, but not as a lawyer, but when you come to analyse his knowledge, what he knew or ought to know, then you judge that against the background that he is a lawyer. And again, I accept entirely Lord Hughes's point that it would have been fair, had the evidence supported it, to say you judge that, but there's no attempt to look at the evidence about what he did know as a lawyer. And then he goes on to say, really getting into his stride here at line 12, 1380, I say to you that it would otherwise be lawful to reinstate the company which was struck off. In other words, it is lawful to reinstate the company which is struck off of the register, but this can only be done legally by a lawful director of the company or an officer of the company, which, as a matter of fact, is wrong, as we've seen, but never mind. The means by which Warren Cassell tried to reinstate PEL was unlawful. There can be no doubt about that. He was not, and he has never been a lawful director of PEL. In case they missed it, he was not, and he has never been a lawful director of PEL. My Lord, we respectfully submit this would have been going some in a speech for the prosecution. As a summing up, it is quite beyond the pale in our respectful submission. And then it doesn't end there. He goes on at 1381, at line 23. That application, I told you, was without merit because Warren Cassell had no standing to make the application. Would have known that fact. Let me repeat, Warren Cassell had no standing in law to make the application to reinstate PEL to the Register of Companies. Would have known that as a fact. Quite how Wood is supposed to know about Montserrat, the Montserrat Companies Act requirements for reinstatement of a company. The jury are not told, but they're simply told would have known that as a fact. So here is an agreement between both of them to do something unlawful to reinstate a company, because Wood wrote a statement. So that is an agreement by them to do something unlawful, for him and his company to do something unlawful. Well, that alone in our submission is fatal to the safety of the conviction. I'll come back in due course to the proviso point, but we say that alone is fatal to the safety of the conviction. The jury are told in terms that there has been an agreement to do something unlawful right at the start of this process. But he goes on then to say another reason was the concealing on the face of the court of Rooney's position in PEL, both by Warren Cassell and Wood. I'm sure you would have no difficulty in finding that the sworn statement concealed Rooney's position in the company. The application and the affidavit by Warren Cassell concealed Rooney's position in the company, never even mentioned his name. You may ask yourself why. Didn't they know he exists? Didn't they know he was the director of the company? Of course they did. So why conceal it? It is to deceive the court, I suggest, because had the court known the true facts, no court would have granted that application. The purported sale of his, Wood's, shares to Warren Cassell must have been known, and Warren Cassell must have known, deemed to have known, being a lawyer, that the sale was unlawful. The condition of sale of Wood's share was in the Article of Association. He goes on, another reason why the sale was unlawful was in the Articles of Corporation, objects for which Cassell and Lewis was incorporated to acquire and do with any property, real and personal, and to erect any buildings, etc. And at the bottom of the page, I'm sure you would have little difficulty in finding as a fact that Cassell and Lewis was in competition with PEL by its Articles of Association. If you do so find that Warren Cassell or his company could not lawfully acquire shares from PEL, Warren Cassell would have known that, and Walter Wood must have known that, deemed to have known that, because Cassell and Lewis memo and Articles of Association is registered in the company's register, and it is noticed to the world. Yet Wood and Warren Cassell entered into this agreement to unlawfully acquire shares in PEL, that is Walter Wood shares. I say to you that any agreement by Wood and Cassell, if you so find, was the vehicle to put in motion to achieve the objects to defraud as alleged by the prosecution of the valuable securities by the purchasers. Because if the company PEL was not restored by Cassell, I say that restoration was aided by Wood. There is no doubt about it. Then Cassell and his company would not be able purportedly sell the lands to these purchasers. So, my Lord, that's what the judge says at that stage, and in our submission simply leaves no scope at all, really, for the jury to form their own view about dishonesty or otherwise. It simply withdraws the issue from the jury and tells them in terms that the behaviour of Wood and Cassell amounts to a conspiracy to defraud, and that there really isn't any sensible argument on the subject.
Yeah, well, you will say it, and one understands the submission, that it's too little too late. But the judge does actually finally turn to the question of dishonesty as an ingredient of conspiracy to defraud at 1388, isn't it? It's after their mid-morning break. That's right, yes. He perhaps...
one doesn't want to engage in hyperbole, so I won't. But I agree. At that point, the judge adopts a rather more judicial attitude to matters and does tell the jury what to defraud is. But I do say it's too little, too late. It's far too late by this point, because the jury has already been told, essentially, that there was a conspiracy to defraud, and he's now simply telling the jury what it is that they should find. And the way in which the judge also directs the jury about the appointment of Meredith Lynch as temporary secretary and the land transfer signed by Warren Cassell and Meredith Lynch and Cassell as director of PEL is also notable. This is page 1386, just before the point that Lord Torsten just went to. Before the break, the judge says, it is not worth the paper it is written on.
Sorry, where was that?
This is 1386, line 17, my lord. My Lord, it's a feature we submit of the summing up that at times it is so plainly something which resembles a second speech by the prosecution that the jury can have been in no doubt about what the right outcome was. And you see that again at page 1390, where having given the direction, which I accepted for a page or two is relatively unexceptionable, about defrauding the purchasers. The court says, in this case, Warren Cassell, according to the prosecution, was masquerading, in my word, as the legal director of PEL. And that he and his company, Cassell Lewis, had the legal authority to sell PEL. So he ramps the language up, even from what the prosecution had said. He induced the purchasers of PEL land to believe that to be true, that he, Warren Cassell, had the authority, the legal authority to sell land which he knew or must have known was untrue. And then he must have known that to be untrue because he is a lawyer. And he must have known of the memorandum and articles of association of the company PEL, or deemed to have known the memo and articles of association. Then he does go on fairly to say no one can prove positively knowledge and intention. But then that's all pretty academic as far as the jury are concerned, because he says at the bottom, 24, as I said, Warren Cassell must have known that it was unlawful to appoint himself as sole director. He must have known that he did not have authority to appoint Meredith Lynch as secretary. You are entitled to infer these things because he is a lawyer, and moreover because the Articles of Association of PEL is a document registered in the Registry of Companies and therefore knowledge to the whole world, but he induced persons to believe that he had the legal authority. And this is another recurring theme of this summing up, that somehow because the articles are registered and are publicly available, therefore it follows that there's really no need for the prosecution positively to prove that Mr. Cassell knew that he was doing something that was inconsistent with them. Well, that's wrong on so many levels, my lords, because it skirts over completely the question of whether Mr. Cassell knew about had actual knowledge of the articles at all, and whether if he did so, he knew that what he was doing was inconsistent with them. My lord, can I then go to 1394, because it doesn't stop there. We are now in the territory of cheques being paid to Cassell and Lewis, inducing the purchasers, it said, to believe that there was authority on the part of Mr. Cassell to sell the land to them. Line 9 on page 1394, Cassell and Lewis could not believe that they had the legal authority. Remember, Cassell and Lewis is acting through his director, Warren Cassell. Cassell and Lewis could not have known and could not believe that they had the legal authority to sell PEL's land. So there's another issue withdrawn entirely from the jury. Not the question for you is whether they believed they had authority to sell the land, but you couldn't do it. It's also rather confused because and it's a confusion which stems actually from the indictment, even it's an amended form, because the sales of the property were sales that were done purportedly by PEL on the signature of Mr. Cassell. It's rather unclear what. We haven't made a point of this in the light of everything else, but it's rather unclear what role Cassell and Lewis Inc. in fact had at all in the sales of the property. The purchasers are not led to believe that Cassell and Lewis Inc. is playing any part in that at all.
Well, there's at least a prima facie case that they're party to whatever is going on because they receive the money, don't they?
I agree, they receive the money, but that's different from what the judge is saying here.
I agree with that.
But the charge is conspiracy, isn't it?
Yeah.
Well, on the conspiracy, that I can see that makes sense. It doesn't make sense on the
Procuring.
It doesn't make sense on the procuring valuable securities by deception.
Well, they're joint charges, aren't they?
Yes, both sets of charges are against both defendants. Yeah. Yes, well, my point is that in relation,
there's no difference between a conspiracy and a joint charge in this respect, at any rate, is there?
Well, that wasn't the way it was articulated by the prosecution.
Follow that.
So, certainly, it's not. I don't think it's a point we need to spend too long on because there's better material on other points. But certainly in relation to the charges, it's a bit hard to see what the charge was supposed to be in relation to the procuring the execution of a valuable security. What was it that Cassell and Lewis Inc. did to procure the execution of a valuable security by dishonesty. One can see the way it was put against Mr. Cassell because he signed as director of PEL. But there's no evidence that the purchasers knew that they were, or thought they were purchasing from PEL as authorised by Cassell and Lewis. Anyway, my Lord, I think I can then skip over a chunk of the summing up, and then we get back to...
So they were the shareholders, weren't they?
Yes,
The purported shareholders.
The shareholders or purported shareholders in Provident Estate Limited.
So it's a bit unreal to suppose that insofar as he acted, he wasn't also acting on behalf of them, since it was they who had the formal position. Well, just as much as he did, he was a purported director, I suppose. Yes.
I can see that point, my Lord, but it's a bit more attenuated to talk about the shareholder acting, because in the course of the sale, it was the company which purportedly through him was making the sales. Anyway, my Lord, 1409 is another passage I wanted to take your Lordships to. Of course, the prosecution, this is line 7, is alleging that representation was false. Here we're talking about representations to purchasers of entitlement to sell the property on behalf of Provident Estate Limited. You will have to determine if that was false or not, having regard to what I've just told you. Have they proved that the representation was false? The prosecution says that there is an abundance of evidence in support of the falsity of those statements because Warren Cassell had no legal authority to sell any land belonging to PEL, and legally he was not a director of PEL, and he must have known that, ought to have known that, and deemed to have known that. And again, in the light of that, you will take into consideration the way the company was reinstated. He had no legal authority to reinstate the company, had no legal authority to declare himself director, none whatsoever, etc., etc. So again, the jury are told that Mr. Cassell, was deemed to have known that that he had no authority to act as he was acting.
Yes, now there's been a change of gear in the sense that the judge has now gone away from conspiracy into the substantive counts.
Yes.
And he has given them, in relation to that, a direction which, purely in terms of the law, would be unobjectionable. It starts at 1396, line 22. I now direct you on counts 3 to 13, inclusive of the indictment. And then he goes through the various ingredients of that, and dishonesty comes in at 1399, bottom paragraph. The section under which the two accused are charged are any person who dishonestly, with a gain to view to gain for himself, procures the execution of valuable security shall be given in events, and then he goes on to dishonesty.
Yes.
Quite a lengthy passage on 1407 on this.
Well, that's a Gosh direction, isn't it? Which, so far as it stands, is positively favourable. But how far it gets you, anybody, I'm not sure.
Yes. I mean, I certainly accept, my Lord, that from time to time in the summing up, the judge gives textbook directions on the law. In fact, in relation to the false representations, I'll come back to it in sequence when I get to the end of the summing up, that a lot of such good, if any, such good as there was in relation to that point is significantly undone by a passage at the end of the summing up where shortly before the jury are sent away, the judge, we say, essentially tells the jury there's no need to worry about mens rea in relation to the defrauding charge either, in relation to the deception charge either. But I accept, my Lord, certainly that from time to time there are parts of the summing up which are unexceptionable, but one has to take it as a whole, of course, and there is such an abundance of material which essentially tells the jury what they've got to do that it can't be saved in our submission by those points. So I think I was at 1409 pointing out that yet again the jury are told that Mr. Cassell is deemed to have known that what he was doing was unlawful. I suppose it might be said in relation to that passage that it's governed by the words, of course, the prosecution is alleging. But then if that's what was, I'm not sure that is what the prosecution was alleging, and if they were, the judge's duty was to say that they were wrong about that. My Lord, we then go to another aspect.
How about the time? We sat at 10. you indented originally for 2 hours and a 30 minutes reply. So we're...
Well, I'm on my 2 hours, my lord.
Yes, you are indeed. How much longer are you going to be in? What about Mr. Knox is indented for rather a long time. I'm surprised at 2.5 hours. Are you really going to take 2.5 hours?
No.
I wouldn't expect it, but then our expectations have been disappointed already. Well, how much longer are you going to be, Mr.
Well, my lord, can your lordship, if your lordship can give me another, I mean, I'm almost through the summing up, and then we're really into a few short submissions on. The summing up is and I don't think my learned friend is, well, that's very kind. My learned friend's offered me his half hour, so that he doesn't want, so I'll try not to take all of it, my lord.
Yes.
My lord, there's then this discrete aspect of the summing up, which I suppose we'd accept by itself wouldn't be enough to render the conviction unsafe, but it's another very unsatisfactory feature of the judgment, which your lordship has already identified, which is that from 1417 onwards, the judge says that he's going to refer the jury to what he calls the salient aspects of the evidence. That's 1417, line 20.
Well, he then seems to read out...
He simply reads his notebook.
Endless evidence.
And this picks up on our point 4 of our various ways in which we say the trial was unfair. That
Well, if you don't succeed on what you've had so far, Mr. Ray, you're not seriously suggesting you're going to get home on that.
In terms of a summing up, it's quite apparent that this is far, far, far too long, and in order to present the matter properly, it should have been approached in a different way.
Yes, it leaves the jury. Our fourth point is we leave, and I accept that it's maybe academic if we're right on our other points, and academic if we're wrong, I suppose. But I accept that. But our fourth point is that it's quite hard to see whether the jury really understood what on earth was going on after. Certainly, they weren't assisted in it by the judge doing what he did. But then Then the judge gets back, having done that, to directing the jury. Essentially, we say as to what they should find. 1528. He goes back to the conspiracy aspect of it, and he says that he, not altogether wrongly, says that 1528 line 6 counts 1 and 2 charges both accused of conspiracy to defraud, tells them what that is. I have pointed to you 16. Conduct, if you accept, you will have no doubt in inferring an agreement. 1, the application by Warren Cassell to restore PEL to the Register of Companies. That was an unlawful conduct. The sworn statement of Walter Wood in support of Warren Cassell application to restore PEL. That too was unlawful act by Walter Wood, because Walter Wood would have known that Warren Cassell had no legal authority to restore PEL to the Register. The purported sale of his Walter Wood shares to Warren Cassell was also an unlawful act, because Walter Wood would have known that he could not legitimately sell his shares to Warren Cassell and Lewis Inc. unless he first offered those shares to Rooney. He did not. This was another unlawful act, an unlawful means, by disposing of his shares to Cassell and Lewis Inc. Warren Cassell, who is the brains, so to speak, of Cassell and Lewis Inc., must have known that it was not lawful to purchase those shares. He's a lawyer. The memorandum of an Articles of Association are registered in the Registry of Companies. He is deemed to have known that he could not have lawfully purchased the Wood shares in the manner in which he did. My Lord, there's nothing left for the jury to do in the light of that, in our respectful submission.
Well, the one point which one would have thought that would be focused on is could he honestly have thought that he had become a director pursuant to a meeting of which no notice was given to one of the shareholders?
Well, that slightly conflates a number of questions, doesn't it? Because whether he honestly believed that he was a director is not quite the ultimate question. The ultimate question is whether there was as per the charges, whether there was a conspiracy to defraud the company and Rooney by some unlawful means, and whether the purchasers were deceived dishonestly by Cassell and Lewis.
Yes, but I mean, if he knew that he hadn't got the requisite corporate authority. He hadn't properly become a director because a 40% shareholder had never had an opportunity of participating in that decision. Then he obviously got Wood to subscribe to that application, and there would be a strong case of conspiracy, wouldn't there? But that doesn't, I mean, whether that's the right way of putting it precisely or not, is it put here at all, that particular point?
Not really, my lord. I don't think it is. And it's not, in any event, it's not, I mean,
The focus seems to be on things like, did he realise that he couldn't, did he and Wood realise that they actually couldn't sell the shares one to another because of the preemption right, or alternatively, possibly, though you poo-poo this with some force, because of the non-competition point, which does seem to be a very small point.
Yes, well, that's right. But even if there had been, as it were, a finding of fact that he wasn't a director and that he knew he wasn't a director, it still doesn't quite equate to a finding that he's guilty on the charges, because what if the position is, again, I accept there's no positive evidence to this effect. Indeed, I accept that his doc statement was to the effect that he thought he was a director. But what if his overall thinking was to the effect that although he wasn't technically a director, the fact is he'd taken an assignment of the majority of the company, and he was he was dealing with a man who wanted to get out, and in due course it would all turn out all right. I mean that's that. I accept.
I'm afraid to say that is the mentality of the person who borrows from the till on the basis that they intend to repay it next week, isn't it? That's no answer on the question of whether you honestly can do or believe you can honestly do what you...
It's not quite the same, my lord, because as far as the purchasers... Well, so far as the conspiracy... It's not as far as the conspiracy to defraud is concerned, because in your till analogy, if the ultimate intention is to put the money back in the till, that's not a conspiracy to defraud. And in relation to the specific charges of obtaining a valuable security by deception, equally, if he believed that ultimately he was in a position to
have to believe
cause the company to sell the property, then or to ratify subsequently, then
that can't be right. Can it? I mean, if you three of the transactions were on the same day as the 21st of September. It's not good enough. It couldn't be good enough for him to say, "Oh, I thought that I would get everything squared out and my authority to enter into these transactions ratified at some later date." He would still have deceived the purchasers into actually entering into purported but non-existent contracts or invalid contracts.
Well, save, I suppose, that in due course there were applications for registration, some successful, I think, of those contracts. So it's difficult to see quite how the purchasers ended up with, at least in the cases where they're registered, with title to the property.
Not quite the question, is it, Mr. Rowe?
No, I can see. I can see that.
Whether any deception operated on them at the time when they parted with the money.
That I must accept.
I'm conscious you're running out of time, but I'm intervene to help focus and possibly shorten things. The relevant parts of the indictment fall into two. We've got the two conspiracy counts and the obtaining by deceptions. In relation to the conspiracy counts, the two effectively stood together, and it was effectively a charge of a conspiracy to defraud Mr. Rooney. A PEL was added too, but effectively the gravamen of it was this was a conspiracy to do a part owner out of his share, having failed to get a settlement agreement with him. The weakness, the fundamental flaw of summing up, is it simply doesn't focus on the case in that way. It looks at all the unlawful means, and was this bit unlawful and that bit unlawful, but simply fails to focus it on what is this conspiracy about? Was there a conspiracy to defraud Mr. Rooney? To that issue, there were a series of extremely forceful points, not informing Mr. Rooney, keeping the money paid directly to his own company. All that went to substantiate But it seems to me that your easiest part is to show that in relation to that whole part of the case, the judge simply never got the jury to focus on what mattered. You then have the separate question, which is, was it so appallingly bad that you don't enter proviso territory, or was there in fact any credible answer to the charge that this was an attempt to defraud Mr. Rooney? That's what counts 1 and 2 boil down to, isn't it?
Well, I suppose, yes, in broad terms, I accept that summary with the addition of our point that in relation to those counts, we would say in relation to all of the counts, the jury were essentially told what to decide. The whole tenor of the summing up essentially directs the jury to convict both appellants on all counts.
Well, that's your points 1 and 2. 1, the judge never focused it, and
Yes.
2, you don't get to proviso because effectively they were told what to do.
My Lord, that's essentially it. I accept that. My Lord, very briefly, because I'm conscious of the time, I wanted to pick up one last reference in the summing up, and that is 1532. And this is the execution of a valuable security by deception counts that's being talked about here. We can pick it up perhaps over the previous page at 1531, line 23. To execute a valuable security, I told you that check, wire transfer, which is conceded to be wrong, but that's gone by the by now, land transfer are all valuable security. Prosecution must also prove that purchasers of the lands in question execute, that is, sign the valuable securities in favour of the accused, Warren Cassell and Cassell & Lewis Inc., because by deception, that is, the accused Warren Cassell and Cassell & Lewis Inc. were lawfully entitled to sell the land in question, PEL land and Rooney's land. The false representation is telling, indicating to those purchasers that they, Warren Cassell and Cassell & Lewis Inc., were lawfully entitled to sell the lots in question, which is in fact, as I told you, were false. These representations by conduct, that is, if you sign as a director of the company, and in truth and in fact you are not legally the director, you are representing to the purchasers, or would be purchasers, that you are entitled to sell PEL's land because a director of the company will be able to sell PEL land property if he's given authority by the company, with a view to gain for themselves that checks were paid to the account of Cassell & Lewis Inc. did not go to the account of PEL. Therefore, you should have little difficulty in coming to the conclusion that what was done, that is monies realised from the sale of those plots, went to the benefit of Cassell and Cassell & Lewis. I told you that if you accept all of these, to the extent you feel sure of all of these things, then you are duty-bound to return a verdict of guilty in relation to counts 3, 4, 5, 6, 7, etc., because all these counts in the direction of count 3, which I've just given you, relate to the other counts, etc. That is, the dishonestly procured the various individuals named in those counts. My Lord, our point about that, my Lord, is that is what the jury are essentially sent away into the jury room with. There's on that page 1532, the judge essentially tells the jury that if false representations were made, then the charges are made out. And, of course, that omits entirely the mens rea.
Exactly.
Well, isn't the mens rea a bit earlier? I mean, he says on 1531, I told you how to approach the question of dishonesty. And he repeats then the Gosh test, I think. And then also on 29 and 30, 1529 at line 17, I told you to defraud is to deprive by deceit, etc., etc. And then over the page, I think he goes a bit wrong, you would say, at lines 10 and 11, where he says, for example, signing when he was as a director when he wasn't could be a false representation because he was never legally a director, and he must have known, or you ought to have known that because he's a lawyer. He, Warren Cassell, but not in these circumstances, honestly believed that he was a true legal director. So.
I'd missed that one, my Lord. This is a summing up that every time one looks at it, new things jump out.
Yeah. So, I mean, you say it's every time he gets it right, he gets it wrong.
Pretty much. That's essentially it. And it's certainly true that you can extract bits where accurate directions on the law are given. But what matters I would suggest, in practical terms, from a jury's point of view, is how that's then applied to the facts of the case. And it's no good telling them in the abstract that you need to find dishonesty if you then go on to tell somebody to tell somebody that as long as they're satisfied that there's a false representation, they're duty-bound to give a guilty verdict, which is exactly what the judge says at pages 1532 to 1533.
Right.
If you accept all of these to the extent you feel sure of all these things, then you are duty-bound to return a verdict of guilty, and that's in circumstances where he's just summed up to them these things that he's just summed up to them, which require them to give the verdict of guilty, are the fact that the representation was false. Yeah. So, my Lord, unless there are any other aspects of the summing up that the Lordship wanted me to deal with, that's what we say about the summing up. Those are the bits of the summing up that we in particular rely upon. And it's in that context that we then make essentially our 4 points, which I can make fairly shortly, together with our fifth point, that this isn't a proviso case. And your Lordships don't need me to, I'm sure, to go to the law on the duty of impartiality, etc., etc. It's all very clear black letter stuff. This was, we submit plainly, a case where the judge went well beyond the boundaries of permissible comment and essentially withdrew the case from the jury. It can't be said in our respectful submission, or it certainly shouldn't be said in our respectful submission, that the defendants had a fair trial in the light of that summing up. That's true across a whole series of different issues. It's also, we make the second point that there were some aspects of the matter which were favourable to the appellants, favourable on the question of honesty, and I quite accept your Lordships have quite rightly subjected me to a degree of sceptical questioning about this aspect in the light of the evidence. But if one was concerned, if the judge had been concerned fairly to set out to the jury the matters which, on the evidence, failed to be considered, and I haven't got time to take your Lordship to it now, but we rely, for example, on the von Stark case, which is in the authorities bundle, which is at, I don't go to it now, but it's at tab 15 to 2980. It's the case of the board reiterating the principle that that's in the question in the context of evidence, that whatever prosecution or defence counsel have said, if there is evidence which is favourable to the defendant, then it ought to be drawn to the jury's attention. And there are some aspects of the matter which are a little odd, perhaps, in the context of both a conspiracy to defraud and obtaining property by obtaining valuable securities by deception. The fact there had been a transfer of the shares, that had been registered, the fact that the company had been restored to the register, the fact that there had been, as was said in the assertion anyway, in the doc statement, that there had been proceedings taken by Mr. Cassell. These are matters which, however much in the cold light of day some years later this court might be pretty sceptical about when it comes to considerations of whether he was acting honestly or not, nevertheless ought fairly to have been mentioned at least to the jury as being things which were perhaps arguably inconsistent with the dishonesty. I mean, putting it its most blunt, if this was dishonest, why did he go to such elaborate lengths to do all those things rather than simply forging a document somewhere along the line in a crude fashion? This was...
Well, you had to have some basis for selling to all the purchasers, I suppose. I mean, to suggest that he didn't need to do most of these things would be putting matters a bit far, wouldn't it? He needed to appear to have control of the company, and the point made against you, which could have been made, I think, quite forcibly, is that it does appear he was prepared to cut corners fairly tightly, if not over tightly.
Well, that was exactly the issue that was for the jury, and in the context of the corner cutting, the question is, does it had it been fairly put to the jury, the question might have been put something along these lines, accepting that it does appear that there is evidence that the corners were cut, but do you find, looking at all of the evidence, that it was done in such a way as to be dishonest? Or is it possible that, in fact, what was happening here was a lawyer who thought that he could use his knowledge of the system and the fact that one of the majority shareholder was prepared to sell out to him, and that he was at least able to get into negotiations with the minority shareholder, Was he able to use that to turn it to his advantage, albeit cutting corners along the way? I mean, I quite accept that, particularly looked at from the present perspective, in hindsight, it's not very attractive conduct, but that wasn't the issue. And there was really no help given to the jury on any of the aspects which, at least arguably, might have been inconsistent with dishonesty. But that's very much a secondary point, because our primary point is that the jury essentially had the issue withdrawn from them, and that, as we say, it's one of those cases where, as we quote in our case, as Lord Lane put it, their comments so weighted against the defendant that the jury have little real choice other than to comply with what are obviously the judge's views or wishes. It could not have been.
That's a quote from where?
That's a quote, my lord, from Mears and the Queen, 1993, para 15 of our case.
Thank you.
Mears is a case where they go on to consider whether to apply the proviso.
Yes, in fact, my lord, that's a point I'll look at in a second when I come on to the proviso.
It struck me as being perhaps the most significant of the cases in our bundle, because of that very point. I mean, the proviso wasn't closed off because of the unfairness of the trial.
Well, perhaps I can go to it, my lord. Since
The whole question on the proviso is whether there's been a miscarriage of justice, isn't it?
Yes. Well, may I deal with that squarely, since that's the way. I mean, I'll come back on and reply on this, depending on how my friend puts it. But the way in which we put the case on the proviso is simply to say that we simply never get to the proviso because you do have to have at least something which resembles a fair trial before you can get onto that stage. We cite Randall, for example, where the board said through Lord Bingham that there are cases where the departure from proper standards is so gross that one simply is driven to the conclusion that there was not that the substance of a fair trial was denied. And can I look at how that's dealt with, though?
Was there any consideration of a proviso in Randall? I didn't find any, but I may have missed it.
My lord, what happened in Randall was that Randall is tab 10.
Yes, however strong the grounds for believing the appellant to be guilty, and that's certainly provided type.
Yes. I mean, certainly in the submission made in Randall was essentially the submission my learned friend makes in this case. What Mr. Perry said there was that it was an overwhelming case against the defendant, and your lordship sees the answer that your lordship has just quoted to that.
Which paragraph is that?
That is
28, I think.
my lord. Yes, 27 and 28. The board sees great faults in many of the points made by Mr. Perry for the prosecution. The case against the defendant does indeed appear to have been a very strong one, and the explanations proffered by him might well have been properly rejected by a jury. Grounds for criticising the conduct of the defence and the evidence of the appellant. He'd given evidence in that case. But then, it is not every departure from good practice renders the trial unfair.
Yes, that's the antecedent question. As Lord Reid says, that's the antecedent question. Has there been, has summing up, or the trial in this case, been properly conducted? The proviso question only arises if it hasn't. And I'm slightly puzzled by your suggestion that we don't get to it.
Well,
why didn't it get to it in Randall? Why?
Well, but it's essentially, my lord, that Randall was a case where it was a proviso case. There was not a word of submission on Mr. Perry's part in Randall in defence of the way in which the prosecution counsel had conducted the trial. Indeed, we were talking earlier about timings. That appeal before the board was occupied by about a day and a half of the appellants going through the transcript, pointing out things that had gone wrong, followed by about half an hour, I may be exaggerating from memory, but a fairly short period of Mr. Perry saying, yes, we accept all of that, but the case was an overwhelming one. So, I mean, essentially one was in the territory of the proviso. So when I say you don't get to the proviso, I put that badly.
Yes.
Of course you have to consider it, but it's not really open in cases where, as Lord Bingham puts it, the departure from good practice is so gross or so persistent or so prejudicial or so irremediable.
Which paragraph is that you're reading from?
It's 28, my lord. Can I just
So that is
About halfway down, the key point is this, really, isn't it? But the right of a criminal defendant to a fair trial is absolute. There will come a point when the departure from good practice is so gross, etc., so persistent, so prejudicial, so irremediable that an appellate court will have no choice but to condemn a trial as unfair and quash a conviction as unsafe, however strong the grounds for believing the defendant to be guilty.
Well, the key to that is perhaps irremediable.
And also the last sentence of paragraph 29, where they actually seem to be justifying the conclusion because they can't be sure that the matter...
Cannot be sure that the matters of which complaint is made
That
together.
is also with the court,
Yeah.
with the somewhat cautious words in paragraph 27, great force in the points made, appears to be very strong, explanations proffered might well have been properly rejected by a jury. Court was not saying this is one where really we, on examining the case ourselves, can see that it was unanswerable.
No, but I suppose, my Lord, what we do seem to derive from Randall is in its own terms, it says there does come a point where it becomes inappropriate for the court on appeal really to venture into the territory of saying, well, is this a case for the proviso to apply? I accept the issue is addressed, but the answer becomes obvious to that because the trial is so unfair.
You can't substitute yourself for the jury. That's
essentially the point.
I mean, no good, Mr. Knox, persuading us that if we'd been there, we'd have convicted.
That's the point, my lord. Your lordships aren't the jury.
That's not good enough. But if he persuades us that any jury must have convicted, then on the face of it, that's different, isn't it?
Even that, in my submission, my lord, in principle, no, because the entitlement is to a trial by the jury. I mean, suppose a hypothetical case where the judge simply comes into the court and says, members of the jury, I'm not going to bother summing up. I direct you to convict. In those circumstances, it would not be, in our submission, it would not be appropriate for an appellate court essentially to commence again the process of dealing with the question of guilt or innocence. This was a matter for the jury.
The proviso has been around a very long time, and presumably, what you're really, I think, saying is that it's to do with what one means by a miscarriage of justice. I think your submission has to be along the lines that it's a miscarriage of justice for a conviction to stand where the accused has not received any semblance of a fair trial, regardless of how strong the evidence against him might have been.
Yes.
You can test it perhaps with a rather obscure, rather extreme type of case. But I mean, if you had a case where the summing up had simply failed in an assault or a murder case, in which the summing up had simply failed to deal with the burden of proof or the standard of proof, and had been larded with the kind of pejorative comments that you rely on in this case. But there was a closed-circuit television of the defendant doing it. Then what?
Well, my lord, we would submit that in principle what the defendant is entitled to is a fair trial.
I understand that, of course.
By a court of first instance, and that's
A
that.
fair process. I know we're not in Strasbourg territory, but there can be circumstances where the dealing with the matter at the first level tribunal is unsatisfactory, but the reviewing panel is able to re-examine and, making every possible allowance, conclude that there is not a miscarriage and letting the result stand. Now, whether it's appropriate to do that on the particular facts is fact sensitive, but one's got to grasp, I think, the question, what answer was there to the allegation that he was trying to carve out Rooney's acknowledged interest in the company for which he was prepared to pay a sum, and when that didn't work, he keeps him out of the loop, purports to have meetings, which, whether they happened or whether they didn't, did not involve a person who was entitled to be there, then has the company restored register, gives himself a semblance of authority, and takes the money for his own purposes. One looks to see, well, what answer was offered to that? And at the moment, I haven't seen any.
No, I agree, my lord, that I can't point to, because the defendant didn't give evidence, I can't point to any evidence that he gave. I can only point to the statement that he made from the doc, and to what I say are, if we're in this territory at all, and I don't entirely resile from my first submission based upon what was said by the board in Randall that we're not in the territory, but in that territory. But if we are in that territory, then I suppose I essentially say, well, we're in the territory of the court needing to be sure, and that's a high standard, and it's not satisfied on the evidence in this case. However sceptical one might be, when one takes into account the fact that there was on the face of it, genuine transfer by the majority shareholder, which on the face of it was paid for.
But why does that go to the question of whether after that had been taken, there followed the deception?
Right.
Because it goes to the question of dishonesty, because if
But no one was
because it's consistent with an honest, if perhaps rather sharp, attempt by someone in the defendant's position to exploit this situation, exploit Rooney's weakness, practical weakness as the minority shareholder. Suppose for a moment that if one admits of the possibility, which in my submission one should admit of, that Mr. Cassell did not appreciate the restriction on the transfer of the shares, so thought that the shares were freely transferable. Well, once you strip out all that stuff that the judge said about how it couldn't possibly have been the case and accept the possibility that he thought that he was now bona fide, at least the owner of 60% of the company, he's got an offer from Mr. On the evidence from Mr. Rooney to get the rest of the company for $300,000, which he's prepared to accept. Albeit I accept as a matter of contract law, there's no agreement because he puts a counter offer which is not accepted, but they're on the cusp of an agreement on the documentary evidence about that.
Well, where do we get that? Sorry, Randall, that you put a lot of understandable reliance on, is one where the appellant had proffered explanations which the board said the jury might well have found extremely thin and rejected.
I get that.
Difficulty in this case is I can't at the moment see that there's been an explanation proffered at all. Now, you're suggesting that actually he thought that he had a done deal with Rooney, that it was all a matter of he was simply jumping the gun somewhat by cutting him out of the loop. When has he ever said to anybody, I thought I had an agreement with Rooney and that made it unnecessary for him to attend?
Well, he doesn't say that, my lord. He says in his doc statement that as your lordships have seen, essentially that he thought that what he was doing was legitimate. But my lord, the answer to the question, to your lordship's question directly, what about the fact there was no explanation, is the point that we rely upon von Stark for. Can I take your lordships to that? That's tab 15 in the appellate.
You say it doesn't really matter whether he's offered an explanation
No.
or not. The Crown have got to show that the only proper conclusion is that he was a crook.
Yes. And my lord, the finding of the board in von Stark, a case on quite different facts, but is summarised in the headnote this way, 2980. The trial judge had a duty to place before the jury all the possible conclusions which they were entitled to reach on the evidence presented in the trial, whether or not they had been canvassed by either of the parties in their submissions.
Is that a...
That's 15.
Is it a diminished case?
It's a murder versus manslaughter case.
Yes, it's an unrun diminished, is it?
Yes.
Or provocation,
whether
one or the other.
Intent for murder.
There has to be some limit to it. I mean, is it really the duty of a trial judge to put before a jury something which appears to him to be utterly fanciful and which nobody has ever suggested?
Well, my lord, the question of what the judge's duty was doesn't really arise at this stage. We're concerned now with the application of the proviso on the facts as they were.
But you're saying, but you're relying on Stark as the duty of the court to invite the jury's consideration of all things which are possible.
Yes.
Well,
I suppose
I'm just probing what is, how far you have to take the realms of possibility. It can't be that it might have been done by a man from Mars. I mean,
no.
If something appears to the judge to be fanciful and unsupported by anything that anybody has suggested, is he nevertheless under an obligation to say, well, conceivably, one could imagine that this might have been the case, and run through a list of unbelievables? That sounds a tendentious way of putting it, but
yes. I suppose the answer to that, my lord, is that so far as the judge is concerned, we simply need to say, for present purposes, that the judge misconducted himself in the way that we did, so that the only question which remains is whether you should apply the proviso. As I've said, our primary answer to that is that there are cases, Randall, I accept you can rationalise Randall on the basis that actually it was the application of the proviso, but they decided that the board decided not to apply the proviso. But in fact, the board goes further than that in the judgment to say that I submit, because by saying that the right of a defendant is absolute, and that there are cases where the departures are so gross, etc. I accept so irremediable.
They just don't discuss the proviso. The authority I think you really need to address is Mears, because there it's a case rather similar to this one in that the court, the committee, reached a conclusion that the judge's comments, I'm looking at page 2833.
Yes.
The judge's comments went beyond the proper bounds, made it very difficult, if not practically impossible, for the jury to do other than that which he was plainly suggesting, in other words, return a verdict of guilty. And so...
But I agree, your lordship.
But then
the court then does go on to look at the proviso.
In
the light of that, there is perhaps an inconsistency between that and between Randall taken at its highest, or some of the dicta in Randall, at any rate, where Lord Bingham expresses it in absolute terms, albeit I accept then does in fact go on to conduct what's essentially a proviso exercise of asking whether the court can be sure.
But leaving that apart from them, what you're saying here, as I understand it, is we're past the stage of considering what the judge should have done, or at least on the assumption that we are.
Yes.
We've got to the stage where we are asking ourselves whether there has been a miscarriage of justice, or whether we can be sure that there wasn't.
Yes, and
asking ourselves that, I think you say, the fact that he hasn't offered the explanation that he thought he would might be a bit sharp, but he wasn't dishonest. No one would lose in the end. It would all come right. Is one which we have got to consider whether he has ever advanced it or not.
My lord, that's precisely my point, and I submit that proposition is right in law. It follows logically, if it be the duty of a trial judge to put before the jury all possible explanations on the facts, whether raised or not by the defendant, it must also be the duty of a court which is seized of a case where the proviso applies to conduct the same exercise. And my submission in relation to that, and obviously I'll deal in briefly in reply, no doubt, to more specific points that my friend puts, but my broad submission in relation to that your lordship has, which is that while I'm in difficulty quarrelling with the suggestion that there was cause to be sceptical about the honesty of the defendant, this is not a case where one can be sure that what happened was dishonest. But also, those are essentially the submissions that I seek to make, and I think I've overrun my time a little more, so I better stop making submissions and give way to my friend.
Thank you. Yes, Mr. Dorset. Is there anything you wish to add?
No, thank you. No.
Thank you. Mr. Knox.
My Lords, if I can just summarise my position, I say this is a clear case for the application of the proviso. The first appellant plainly was not validly appointed as a director and could not possibly have believed he was. He didn't put forward any basis for saying he had such a belief. And therefore, on any footing, the appellants, or at least the first appellant, were guilty of procuring the execution of valuable securities by deception. That is, by dishonestly holding himself out as a director of the company with authority to act on its behalf in the land sales. I also say that in relation to the two conspiracy counts, there plainly was a conspiracy with Wood to defraud Rooney and the company of the parcels of land by falsely representing that the first appellant was entitled to act for the company on the sales. And just on some particular points, I just want to make these broad points. I submit that the judge was entitled to direct, as a matter of law, that the purported appointment of the first appellant as director of the company was unlawful and invalid. That's a matter of law, and the judge was entitled to say so. Second, the judge was entitled to direct, as a matter of law, that the transfer of the shares from Wood to Rooney was unlawful. Although that's a secondary matter, because that wasn't actually the issue in the case. Thirdly, he was also entitled to direct, as a matter of law, that the method by which the application to restore the company to the register was made was unlawful. Again, of course, that's not an essential issue in the case, it's a subsidiary issue, but as a matter of law, the judge was entitled to make that direction, for reasons I shall come to. The real criticism in this case turns on the judge's directions in relation to knowledge, deemed knowledge, constructive knowledge, and ought to have known, in relation in particular to those 3 points I've just made. And I accept the judge should not have directed that the defendant knew or was deemed to have known certain matters. Likewise, he should not have directed that Wood must be deemed to have known, or ought to have known, or must have known. He shouldn't have made those directions. I accept that. But what I say as to that is, if the judge had given the directions which he could properly have given on the question of knowledge, both in relation to Rooney and so far as material in relation to Wood, the jury would have come to the same result. And that is because there was simply no basis for the first appellant to have any honest belief, in particular, any honest belief that he'd been appointed a director of the company. But I say also, there was simply no basis for saying the first appellant had an honest belief in relation to the legality of the transfer of shares and indeed the legality of the application to restore to the register, so far as that is material. In relation to the fair trial point, what I say is this. I say that there is really just one single question invoked by the statute, namely, has there been a miscarriage of justice? If there has been a miscarriage of justice, then the appeal must be allowed. If there has not been a miscarriage of justice, then the appeal must be dismissed. This is a matter of statute. And so what I say is essentially this. The test usually applied in applying proviso is, would the jury inevitably have convicted? And I say, as I should develop, the jury would inevitably have convicted, even leaving the judge's misdirections on one side. However, if there is some difference between that test and the fair trial test, and I say that's simply the test, but if in fact there is some difference, let's say there is some possibility that the court would say, well, the jury would inevitably have convicted, but he has not even had the semblance of a fair trial, for whatever reason. If that is, so to speak, some separate test, I say the departures from good practice in this case come nowhere near as high as they did in Randall, or indeed so high as to so high that one can say the appellants were deprived of the substance of a fair, or semblance of a fair trial.
I mean, your first proposition could take us back to the 18th century, or whenever judges said to juries, members of the juries, you've heard your evidence, do your duty.
Well, yes. Indeed, my lords.
Or even, I think, in one instance, the prisoner stole the ducks. Now retire.
Yes. Well, my lords, but one can see there may be certain cases where one might say the evidence was so strong, it doesn't matter how strong the evidence was, the jury definitely would have convicted anyway, but you just haven't had a trial. I mean, that's what it comes to. You haven't really had what can properly be called a trial, hence the use of the phrase substance of a fair trial, semblance of a fair trial. That's the, as it were, the...
I mean, it could be said against you that the defendant hasn't really had a summing up in this case. he's had fairly reasonable speeches, which focused on more or less the right points.
Yes.
Or at least in the right terms. But he's had a summing up, which is of extraordinary length, as I've said earlier, repetitious, rambling, and in a number of respects, seriously defective.
Well, my lords, as far as the length and rambling goes, in my submission, that of itself obviously wouldn't deprive him of the substance of a fair trial. The real question is in my respectful submission, are the departures so gross? That's the phrase used in Randall, so gross. And in my submission, this is not a case where one can say that the departures in the summing up were so gross as to deprive the appellant of the fair trial.
I mean, to my mind, no jury should have inflicted on it this sort of summing up. How they remained awake escapes me.
It might be a good point for me, but no, I accept that point, my lord. Obviously, I accept it would not have been easy for the jury to follow everything that was being said in summing up simply because of its length. But in my submission, the judge does focus certainly on the question of dishonesty, which really was the central issue in the case, and the judge does give proper directions on the question of dishonesty. And in my submission, to say that the judge the summing up simply deprived the appellant of even of the semblance of a fair trial, in my submission is going too far. It is a case where there are misdirections. I accept that. He puts it wrong on many occasions. On other occasions, he puts it right. But in my submission, it was also it's on one particular point he keeps going wrong, and that's on the question of knowledge. Well, I do submit that matters. If this was a case where he got absolutely everything wrong the whole time, then, my lords, that's rather different. But he doesn't get everything wrong the whole time. It's just this question of knowledge he gets wrong. And in my submission, that you can't infer from that or deduce from that there's been an absence of a fair trial. And the other ingredients, if I can put it this way, the other ingredients in the offence, no particular, or the other elements of the offence, no particular issue is taken by my learned friend. As a matter of law, the legal directions are correct. It's only on the question of knowledge that the directions go wrong. My submission, that, you have my point, that doesn't take it outside what you might call, doesn't raise this case to the level of Randall. And, my lords, I do also make the point, while I'm on my feet on this point, in Randall, as pointed out in paragraphs 27 and paragraphs 29 of Randall, the board was careful, effectively, to note that they couldn't be sure that that the prosecutorial misconduct hadn't deprived or inhibited the presentation of the defence.
Yeah.
And that, in my submission, is very important. So that particular issue isn't grappled with. And here we've not got prosecutorial misconduct, which has inhibited the defence.
Well, there's another bit to that sentence, though. You're looking at 2903, paragraph lines 27,
Yes.
internal page 285. Can't be sure that matters of which complaint is made taken didn't inhibit the presentation of the defence case.
Yes.
And distract the attention of the jury from the crucial issues that they had to decide. Now, it is said here that the whole tenor of this summing up took the jury away from that which they critically had to decide.
Well, the question of knowledge, yes, I accept. The summing up was unsatisfactory on that question. It did, however, leave the question of dishonesty.
Yeah.
My lords, obviously there is a nice question as to how far does the summing up have to go so as to speak, to deprive the defendant of a fair trial, even though the result would have been the same anyway. I suppose one can imagine a summing up which is basically, let's say in a complicated case where the judge basically ignores everything and simply says to the jury, well, the man is guilty. I direct you to convict, or effectively says that. And there were many things that could be said. But, my lords, in my submission, we don't get to that stage in this case. And, my lords, there's also the point made by my Lord Reid in relation to the Mears case. One does consider the proviso, even if you've got what you might call unfair comments by the judge, which really leave the jury with little doubt as to what they ought to be doing. And, my lords, in one sense, this is the point in the case, it might be said. Just how far does the judge have to go off-piste before he's held to have fallen over completely, and the trial and the verdict has to be set aside? But in my submission, we don't get to that stage. My lords, can I just briefly just make a few points on the evidence? And these essentially rehash points which I make in the written case, so I hope I can take them relatively quickly, save where I haven't made them in the written case. The first point is this: there's no doubt that the first appellant signed each of the transfer documents and a contract for sale in one case as director, save in one instance when he signed as president. There's no doubt about that. And if I can just give you a short chronology with the references. On the 1st of August 2007, he signed an agreement as director to sell parcel 36 to Dion Weeks. That's page 174 of the core bundle. So that's the first, and that's, of course, well before he's a director in any sense at all. That's 1st of August 2007.
This is all in the statement of facts.
I think it's all in the statement of facts, and it should be in the chronology.
But if you want to just give the page reference, because the chronology doesn't have page references on it.
No, the page reference is core bundle 174 for the 1st of August 2007.
177, isn't it?
174.
Oh, all right.
And then 21st of September
Just point, this is the... Sorry. 1st of
August 2007.
Yep, that's page 174.
174.
Thank you.
That's parcel 36 to Dion Weeks. That's an agreement.
Yeah.
21st of September, you have 3.
No, that is the transfer of the share, 174. You're looking for the transfer of the...
Yes.
It's 177.
177, forgive me, my lord.
Thank you.
21st of September, you have 3 transfers. The references are core bundle 198 for Farrell, and that's the president. Core bundle 201, Joel Osborne.
201.
201,
Yep.
and that's parcel 56, because Mr. Osborne buys more than one. And then 203 for Mr. Cassell and Cleo Cassell.
Yep.
Next is 8th of October 2007 to Mr. Allen. And that doesn't appear to be in the core bundle. The reference for that is bundle 5, tab 74. Then on the 23rd of October 2007, core bundle 221, you have the transfer to Dion Weeks of number 36. In other words, pursuant to the agreement of the 1st of August. On the 11th of January 2008, core bundle 225 is the transfer to Kraus. 12th of February 2008, transfer to Brailsford, which I've only got in bundle 5, tab 77. And then finally, 2nd of May 2008, core bundle 229, a transfer of parcel 35 to Joel Osborne. That's the second transfer to Mr. Osborne.
Now, have you found the evidence of service of the Virginian proceedings before the year-end 2007?
Well, I'll give you my best references in a moment. I'm going to come to that. I'm going to take you chronologically to what Rooney knew was going on.
Yes. I think you've been given some references. They are all in the statement of facts and issues, and actually the last one you've given is, again, not the right document. You've given us the register document, whereas the transfer is tab 84. That's the Brailsford. It's 5/84.
I'm advised by that. My Lords, I just want to make 2 points on the evidence which are not in the statement of facts and issues. The first is this. Even in July 2007, the evidence was that the first appellant had knowledge that there were concerns about his ability to sell the land, and that comes from the evidence of Mr. Thompson, who didn't eventually buy any parcel. What happened was this. He was approached by Cassell, and he said he was interested in buying some land. He then went to talk to his lawyer, who happened to be Hogarth, who happened to be Mr. Hogarth. Hogarth said, "Oh, I can't act. I don't think I can act for you because I act for Mr. Rooney." But Hogarth said, "Well, look, I've got some. There might be some concerns about the sale of this land." And so Mr. Thompson says he then approached Cassell and said, "Look, there are concerns about your ability to sell this land." And Cassell said, "Oh, never mind about that." Now, he places all that in July 2007.
Can we get a reference to that?
Yes, it's bundle 2, or volume 2, tab 17 at 635 to 637 is where you can find effectively the background. And then it carries on to 639, where he talks about his discussion of concerns.
And he's the chap who went to see Mr. Sargent, was he?
Yes. He went to see Mr. Sargent, sorry.
And more to the point, went back to the defendant afterwards.
Exactly. Goes back afterwards and says, well, he's expressed concerns. And this is July. The reason I emphasise it, this is July 2007. And he's quite firm on that. His evidence begins near the foot of 635, and he describes his discussion, 636 to 637, discussion with Mr. Cassell, 636 to 637, and then he expresses, he says what he was interested in. He then says 637, he decided to go to the bank, but going over the page, 638, 4 lines down, I spoke with Mr. Hogarth Sargent to get advice. 638, line 4. And halfway down, Mr. Sargent initially agrees to proceed on the transactions, and then subsequently, he says, line 18, we had a subsequent conversation, and he advised me he would not be able to proceed with my request, as he was also representing Mr. Rooney. Question, I may not have asked you today, a month and so on, when did this happen? This would have been in July 2007. I can't remember the exact day. How confident are you it's July 2007? Very confident it was July 2007. He told you he wasn't able to represent you because he was representing Rooney. That's correct. Did he say anything else to you? Yes, he said there were some concerns about the sale of property. And then he goes on a couple of lines down. I went back to Mr. Cassell and I told him I understand there's some concerns over the sale of the property. The defendant's response was, there are no such issues, there's no concern. He's then asked about getting the loan from the bank. He got the loan. Then over the page, 640, line 5, pays $1,000 to surveying the land. Was a document drafted between you and he? Yes, a sales agreement that was drafted by Mr. Cassell. He'd given me a copy. Did you go ahead with the sale? No. I told Cassell that unless the issue was resolved, I would not be pursuing any interest of purchasing the land. Have you been informed that the issues were resolved? No. And then, that's all examination in chief. And then in cross-examination, page 644, he's asked about the loan from the bank. Top of the page, was it dispersed? Did the bank give you the money? I received a cheque, $116,000. And it was then you had the conversation with Mr. Sargent, correct? As a result of that conversation, you changed your mind. No, I had some questions. I thought it was proper for me to ask Mr. Cassell, and that is why, after speaking to Mr. Cassell, that was when I explained to him that I understand there were some concerns, and I was prepared to hold on or hold off until I was satisfied that those concerns were cleared. Can't recall the exact date as when we had that conversation, but I know we did, and eventually it would have been sometime after July 2007. I don't recall what month it was.
I've just been looking to see whether there's any sign that that evidence was challenged in any way. It doesn't look as if it was.
No.
Right.
So the point I make about this is early on, certainly initially in July 2007, it seems, from the evidence in chief, the first appellant knows that concerns are being expressed. And he just says, never mind, I'm going to go ahead anyway. And, my Lord, the same point emerges from the fact that even on the 1st of August 2007, point I've already adverted for a moment ago, on the 1st of August 2007, he signs the agreement to sell parcel 36 to Diane Weeks as director. Well, on any footing, he could not conceivably have thought he was, whatever else is the case. My Lords, I noticed the time, so I'll deal with the second part of the points I wanted to make, which will cover Lord Toulson's point about what was going on behind Rooney's back, and what did Rooney know, and the question of the Virginia judgment shortly after lunch, or after lunch.
Right. 2 o'clock. We'll look forward to hearing from you further.